Motion. It will appear in the list. No date fixing.
Your Lordship, may I be permitted to mention several matters for exemption of entry on Your Lordship, the entry for the 5 and 30th of November. Your Lordship, I mentioned matters earlier.
30 নভেম্বর গুলো যেগুলো এক্সপায়ার হচ্ছে না সেগুলো একটা দিনে দিয়ে দিন, সোমবারে দিয়ে দিন বা মঙ্গলবারে দিয়ে দিন। You have written the date when it is going to expire.
Regarding item
এগুলো দিয়ে দিন সোমবার।
372, my lord, of your lordship today's list, the assigned matter, my lord, first is whatever number 2, thereafter already deteriorated. Each and every day, my lord, there is a motion matter, my lord, assigned to your lordship, my lord, and another construction is without leaving the mandatory provision of the
motion matters specially assigned begins from 285.
my matter is assigned matter, my lord.
Please see the list. See, open it. Come to 285.
285.
Yes. Please see the heading above that.
285, my lord.
Please see the heading above that. Above 285, what is the heading?
285.
What is the heading?
Specially assigned matters.
So all these matters are specially assigned, not only yours. I am going serially, yours will be taken up. All these matters are specially assigned matters. All right.
No, my
So before
only
so very well. So if there is specially assigned and there is assigned, all are assigned. So before making any submission, please go through the list, make yourself aware of what is there in the list, and then make submissions. All right. And you had made it earlier also. I had indicated it to you.
Earlier on 29th of October.
Very well. Whatever.
You are directed to serve the notice of the.
Very well. You have served this.
I have taken up.
Very well. Thank you. Yes.
Your Lordship, may I be permitted to mention 11 matters for inclusion in the list, Your Lordship? They were appearing in the monthly list of September, and I had mentioned it on 4th of November also, but they are appearing in the list now. And Your Lordship, in this, at item number 4, I have mentioned here, in today's list, it is item number 81. That writ petition, I feel that should be clubbed with one more writ petition, because both the writ petitions arise from the same cause of action. In the earlier writ petition, we had challenged an assessment order, and over here, the writ petition which is there in the list today, we have challenged the penalty order which was passed during the pendency of the writ petition.
Yes, so Mr. Kanodia, I think, had mentioned these matters. No. Very good.
I have given separate requisitions as well, along with the combined list. Grateful, Your Lordship.
Letters, words, officer.
You have not been able to deposit.
No,
why?
They were only cash.
But then you have to make an application that needs modification of the order. I have said payment, you want adjustment. So you make an application to that. Can't be on oral, because payment to adjustment will be a sort of change of the order. Make an application.
May I, Millet, kind leave to mention, Millet, this, let will recall that anti-dumping duty writ, Millet. Let have instructions to withdraw this writ petition. Let them bound by instructions, Millet, I will.
Very well, then it will appear as to be mentioned.
Mine. Deeply obliged. By instructions, Millet.
ওই বড় ম্যাটারটা for non-prosecution, so that I can keep not today, on that day.
I'll get.
কালকে sorry, for non-prosecution.
My lord, kindly to mention one matter, my lord. More than a year and a half back, the Honorable Justice Nizamuddin, as his lordship then was, had been pleased to admit one matter and direct for exchange of affidavits. This is a group 4 matter. The revenue has not filed their opposition yet. My lord, now my client, the petitioner before my lord, is receiving phone calls from the state tax authorities saying that we will initiate because there is no stay. At that point of time, my lord, there had been no urgency as such, therefore the prayer for stay had not been made. Now
Then you have to make an application then. Make an application so that
I
it
make
can
an
come.
application before my lord. I will do that.
Because if no stay is granted, it means stay is refused. So you have to make an application saying that.
My lord, I will do that, my lord, but in the view that more than a year and a half has elapsed and the
Very
revenue
well,
has not
but
filed it,
since this is
opposition
based on
yet.
subsequent development, you should make an
I'll
application.
make an application. Great.
May I permission inclusion for mentioning Unauthorized Construction 1962 Act, Unauthorized Occupancy Eviction Act 1962 Act.
Please give lots.
May it please your lordship, in this matter I am appearing for state, my lord.
Appearing for state.
I am appearing for state, my lord.
None appears on behalf of the petitioner. Full stop. The petitioner remained unrepresented
One,
on.
your lordship, on behalf of the one. Sorry.
Yes. Yes.
Lordship, last occasion, your lordship passed the order for issue notice to the 285, serial number 285.
Item number 1.
Oh, one take it, 285.
Item number 1.
Sorry, I mean 285 টা আমি অ্যাসাইন ম্যাটার ফার্স্ট স্টার্টিং হয়েছে ঠিক সরি বুঝতে পারি
None appears on behalf of the petitioner. Full stop. The petitioner remained unrepresented on previous occasions as well. Full stop. It appears that the petitioner is not interested in pursuing the writ petition. Full stop. WPA 2229 of 2025 stands dismissed for discharge.
Much obliged. With your kind leave, my lord.
Give your appearance.
My lord.
State represented. You are appearing for the state.
I am appearing for state, my lord.
State respondents are to give your appearance in the chat.
My lord, I have already given, my lord.
Yes.
sorry Lordship, last occasion to pass the order for serve the notice again to the respondent number 1. I already served and matter is delivered already, your lordship.
But it doesn't show it has been delivered.
Already delivered
Where?
on the top portion, your lordship, on 17th 11/2025.
Why are they not appearing?
Nobody appeared.
You know somebody who appears for Reserve Bank of India?
Your lordship,
Who appears?
not me.
You appear for Reserve Bank of India, no?
My senior appears for Reserve Bank of India, but she is unable to appear today because of some personal difficulty.
He's briefed in this matter.
Can you please tell me the matter details?
It's item.
Here and now I served the copy of the.
Your Lordship, we were not served a copy with this, so
No, they have served the ombudsman.
We have not received any instructions regarding this matter.
You may not have been engaged, that's why.
But my senior is a standing counsel. I'm here to represent Reserve Bank on a matter in item number 318. So we are a standing counsel impaneled. So
Very well.
we will receive instructions and come back on the next day, Your Lordship.
Very well. None of You file affidavit of service the next day.
The 285, my lord, I am for the petitioner. Your lordship remembers your lordship has substantially heard this matter. And on the last occasion, my lord had shown the rules.
Only one submission, my lord. It's an issue engagement for me, my lord. I am tendering apology. Your lordship, I end up taking up next Friday, my lord. It's a new engagement for me, my lord. It's my yesterday only I have
I am not opposed to that, but your lordship will hear the state. The state is here, my lord.
He is appearing for the state.
Oh, he's he's not a.
That's why we said new engagement.
Coming state.
Oh, correct. In the meantime, my lord, let him take instructions.
To answer the question here is
My
as to whether the rejection of the petitioner's proposed candidature for Muslim marriage registrar on the ground that he has not produced any madrasa certificate like Alim, Fadil, etc. in support of his contention that he has sufficient knowledge in Arabic. Whether this rejection is proper because the notification by which
May I hand over my lord, for his convenience?
by which advertisements were invited, that notification said that you should have adequate knowledge of the subject, Mohammedan law and Arabic.
Arabic, precisely
These
Arabic.
two were requirements. There was no requirement of having any certificate from any institution. Now, this gentleman has produced one certificate issued by a headmaster of a madrasa or something.
Lordship will kindly take rule 5. Rule 5
You go through your rules and assist this court in coming to a conclusion as to what will be the standard then. If you have any other rule on the basis of which you can assess as to how will the adequacy of knowledge be assessed, how will the sufficiency of knowledge be assessed, because then people will have different standards of assessing different levels of sufficiency.
So, my lord, your lordship may kindly please formulate a guideline that this is the criterion.
But then that is to be done by the legislature, not by me. Because that criteria, what is the criteria that you are following? Because
as far as I am concerned, my lord, if
which is so broad that within which anybody can come. Headmaster is certified, so therefore that is also sufficient. Why not? Then how will you answer these questions? So this is something which we have to answer. What
Lord,
is your
as
policy?
far as I am concerned, my lord, if these rules, my lord, are in existence, then perhaps, my lord, I go through.
My lord, challenge twofold grounds. One for my lord the certificate, and second is my residential accommodation.
Yes.
My lord, so far my pending of this read application, I think my lord,
Yes, you had submitted that there was an order.
inquiry was held.
Yes, I have also given a letter to know what is the status, my lord. No answer has been received.
One inquiry was held by the concerned authority. I got the certified copy of the inquiry report. It is also reveals twofold grounds. One for my certificate, and second is my lord the residential.
Very well, we shall hear it then. Likhen in, learned advocate appearing for
Just indicated this thing.
very well. It is for the state to point out.
Yes, my lord. That is the state document. I cannot say that otherwise.
Yes.
I'm grateful, my lord. I have served again, my lord. I have the evidence service, my lord. Appearing and non-appearing, both, my lord, I have served, my lord. My lord, the answering respondent, your lordship, I have pointed out, your lordship also pointed out, my lord, That my lord, the notice content section, my lord, kindly take page 24.
Abhijit Chakraborty is appearing
My lord, he is a non-answering respondent. Let me, my lord, conclude myself, my lord.
My lord, I have taken the initial point before your lordship that the entire cause of action of this case is at Arunachal Pradesh. The writ petition is not maintainable.
But
Your
I have,
lordship
my
will
lord,
see who is the answerable respondent.
but I
Kindly
have
see.
served at least 3 times to the, my lord, the police. They are ignoring the services, my lord. They took the services, ignoring to appear before lordship, my lord. I have covered by a judgment of my lord, not the judgment, but the order of my lord Justice Mantha. My lord, he, my lord, gave a chance to the Karnataka police. Then, my lord, he, my lord, relied upon Naval Kishore, my lord, the crux of the Naval Kishore judgment, my lord, and my lord, passed order on the, my lord, similar facts, my lord. Let me, my lord, place, my lord, page 24 once. As indicated by your lordship, my lord, I have some, my lord. Kindly take page 24 of the writ petition, my lord.
Page 24.
Yes, my lord. Now, this is the letter from the bank. I have served the bank also, my lord. My letter from the bank. And my lord, they says, my lord, the police authorities served them a notice under section 94.
Yes, Mr. Chakraborty, under section 94, how can
No,
there
my
be
lord,
freezing?
107, it has to be 107, my lord.
There
94,
cannot
my
be
lord,
any
to produce
freezing under
records,
94.
to produce records. Someone to produce
Who is
records.
appearing for the bank?
But I have served. But they appeared on one occasion. I have served again. My lord, I am suffering because of their non-appearances, my lord. The
My
bank
lord
is a,
was
my lord.
asking something to me.
Yes, Mr. Chakraborty.
My lord.
How can the bank account be frozen on the basis of a notice under section 94 of the 94 does not speak about freezing.
My lord, may I submit one thing, my lord?
Yes.
My lord, who has asked the bank to freeze the account?
Whoever has asked,
Yes.
Mr. Chakraborty, whoever have asked,
Yes.
if the infringement of the person's right is within the territory of this court can have jurisdiction, can entertain
Definitely I
that.
have. Definitely
Very
I
well,
have.
very well. So if the infringement is within Calcutta,
That is by the Arunachal police.
The infringement is within Calcutta. The bank account which has been frozen is within Calcutta.
Correct.
Action of the
I'm not
bank.
standing in that way.
Huh?
Mr. Chakraborty is not standing on the way.
You are absolutely inaudible.
My lord. Audible now, my lord?
You are intermittently audible and inaudible.
My lord, allow me 1 second time, my lord.
Why aren't you coming physically?
In the network, my lord. I am very sorry, my lord, that I could not attend physically, my lord, today. Now, my lord, I am audible, my lord?
Yes.
Yes. My lord, the whole case is about that they are part of investigation of Arunachal police.
Mr. Chakraborty, I am not entering into that. The domain of the writ petition is very small. Whether the freezing could have been done on the basis of section 94 notice or not, there has to be an order which is implementable for the purpose of freezing a bank account. Now, under section 94 of the BNSS, there is no reason why the bank account should be frozen. Section 94 is a notice asking for certain information.
Correct. My lord, under
Then
section
how can the account be frozen?
My lord, under section 94 bank account has not been frozen.
No, that is page 24 of the writ petition. Please see.
My lord, kindly see page 24.
Yes.
This is from the bank. Bank
Yes.
says that with reference to your letter regarding reason for freeze, bank has received notice from below mentioned police.
Yes.
For marking freezing. For marking police. For marking freeze. Now they have scanned Itanagar police letterhead. Now whether this letter said the bank to freeze the account or not.
Whatever. So the bank is proceeding on the basis of this letter only. The bank is not proceeding on the basis of any other letter. The bank, how could the bank proceed on the basis of this letter?
My lord, let the bank answer that there is this letter does not say that.
That is the my lord thing, my lord. Mr.
You asked the bank to appear.
Mr. Chakraborty, my lord, is not answering respondent. The bank
Mr.
has to or
if on this basis account has been frozen, territorial jurisdiction will not help.
My lord, this is not the basis. The basis of the case.
Apparently, it is. From the writ petition, it appears it is.
My lord, kindly see that page
My lord,
24.
factually, Mr.
What bank
Chakraborty,
has
how
said?
Mr. Chakraborty is, my lord, when I rebutted the facts, my lord, I don't know, my lord. He's
My
appearing
lord,
for
kindly
CGST,
see
my lord.
bank letter. Bank said that it is regarding bank has received notice from below mentioned police station
Yes,
for marking freeze.
yes.
Very well. Then the action, if this letter, the action of freezing is by the bank.
Very well. So bank is within jurisdiction of the court. Bank is
My
acting
lord,
under
the bank is
instruction of the
ICICI Bank.
Yes.
Is not a nationalized bank.
Not required. For every action, bank is acting under instructions. The instruction is wrong. That has to go then.
My lord, instruction is not there. Where is the instruction? Let
This is
bank
the
show that.
instruction, page 24. Mr. Chakraborty, why are you arguing unnecessarily? Page 24 shows that this is the instruction on the basis of which bank is acting.
My lord, I'm not
My
getting
lord,
the
why
instruction.
Mr. Chakraborty is arguing
But
on
I'm
facts,
not
my lord?
getting the instruction. Kindly see,
What shall I see?
my lord, page 24 is a letter of bank to the party, to the petitioner. Correct, my lord?
Yes.
Now, my lord, here bank says that bank has received notice from below mentioned police station. They have scanned a part of the notice which shows that that notice was under section 94. Summons to produce document. The rest part of that notice is not given over here. Number one. Number two, even if not given, it is presumed that that is a notice under section 94. Whether in that notice the Itanagar police has asked the bank to frozen the account.
Very well. If bank has not been asked and still bank has frozen the account showing that notice, that action has to go.
Correct. That is what I am saying. But the writ petition against ICICI Bank Limited,
It is not against ICICI Bank only. The police is also involved.
But police has
ICICI
never
Bank
said.
has to be heard.
Where is the letter
Mr.
of police?
Chakraborty, don't espouse the cause of the bank unnecessarily. Let the bank come and
No,
say what
I
the
am
bank
saying
has
that.
to
I
say.
am saying that.
So
That
फिर
whether
don't argue on behalf of the bank.
And
You argue your case.
and he is not for the Arunachal police also.
Yes. We serve the bank.
Well, I have served, my lord.
Serve again. Let them come.
Yes, my lord. But my lord, then my next Friday, I have some personal my lord, difficulty next Friday. So next Friday, my lord.
The bank, i.e. ICICI Bank, being the respondent number 2, is not represented, full stop. The petitioner shall serve a notice on the respondent number 2, intimating that the matter shall be taken up next on December 5, 2025.
I'm grateful, Rosh.
A further notice shall be served upon all the non-appearing respondents, intimating that the matter shall be taken up on this. Let all notices go on December 5, 2025.
If I drafted the matter, I would not have Mr. Chakraborty's client be party to the matter, my lord. I'm grateful, Your Lordship.
My lord, deeply obliged.
Thank you.
My lord, I am for the respondent WBS.
My lord, I am appearing on behalf of state, my lord.
ঠিক আছে পার্টি করেছো নাথিং টু ডু বললে হবে
Please take the mic.
It is against the WBACDCL for non-consideration of the payment schedule that has been given to the ACDCL Arambagh division for since last 12 years. Several representation has been given, but in spite of that, they didn't release the amount. But I am not on the that whatever amount that is, I am asking just for the consider the representations. Let this repetition be.
Why are you not considering the representation?
Yes, actually what has happened, my lord, my largest now says that he has submitted bill. My office instructions, but office has not yet received bill. Whichever bill he has received, that was paid.
But I have given the second copy of
No,
the
let there be a consideration.
I have also given the second copy of
No, yes, I am not standing in the way. The representation may be considered.
Let it be considered within
the petitioner is aggrieved. Now the petitioner complains that a sum of rupees 6,38,428 word se likhe debe 6 lakh along with interest is due and owing to the petitioner from the respondent
ACDCL
West Bengal
Arambagh division Maharaj.
West minute
West Bengal State
West
Electricity
Bengal
Distribution.
State Electricity Distribution Company Limited, comma, on account of what?
On account of
But I am disputing, my lord, your lordship.
That I will dispute. On
account of erection, installation, and
on
wiring
account
of
of
the
certain works done by the petitioner. Full stop. Paragraph. It is submitted that several representations have been made by the petitioner to the said authority, but none of them have been considered, and the amount and the above amount has not been paid. Full stop. Paragraph. Learned counsel appearing for the West Bengal State Electricity Distribution Company Limited. ওখানে উপরে এক জায়গায় WBSCDCL করে দেন WBSCDCL submits that whatever was due and payable to the petitioner has been paid to the petitioner. Full stop.
But I am disputing that.
And the petitioner's claim is disputed. Full stop. Paragraph. Having regard to the facts and circumstances of the case, comma, since the petitioner has made representations before the respondent authority, comma, it would be proper for the respondent authority to consider and dispose of the representations of the petitioner, comma, in accordance with law. Full stop. Accordingly, the respondent number, who will be the
The concerned respondent, your lordship.
Respondent number 4, my lord.
Arambagh
Regional
divisional engineer.
Regional manager.
He is not the authority actually. Divisional engineer commerce, divisional manager commerce is the authority because the so far billing is concerned. So your lordship kindly direct the divisional engineer commerce Arambagh division.
The competent authority.
Yes.
Of a competent authority of the respondent number 2, i.e. WBSCDC, shall consider and dispose of the petitioner's representation dated
Last representation 17/12/2024. The clear at E.
page
13.
13.
13.
Don't show me from the petition. Where is the copy of the representation?
One 157 onwards, man.
157. 157.
Yes, onwards, man.
Onwards will not do.
One representation which they will consider. Onwards,
I am giving. One 128 is the advocacy representation.
Consider and dispose of the petitioner's representation dated December 1, 2024, within brackets, annexure P7 at pages 128 and 129 of the writ petition, comma, in accordance with law, comma, within a period of
2
weeks.
4 weeks. from the date of communication of this order, full stop, paragraph, it is clarified that this court has not gone into the merits of the claims and counterclaims, claims and refutations thereof, and this order shall neither be treated as a mandate to make any payment to the petitioner, nor a passport to cross over any statutory bar of limitation. Full stop, paragraph.
Grateful.
WPA 1 such है आरेक्टल लिखित
Madam, mandate should
The
be given to
petitioner,
the-
while me not serving the copy, petitioner should serve a writ petition also, because your lordship has indicated in the order.
They have already served. You
No,
take it. No, writ petition service I never direct.
Yes,
This is not
as your.
Madam, mandate should be given to the consideration of the reason within 4 weeks. Madam. They will.
4 weeks I have said. The needless to mention that the said authority shall dispose of the petitioner's representation within the aforesaid period by way of a reasoned order, and shall communicate the same to the petitioner within a week from the date of passing thereof.
I'm always, ma'am.
Full stop. WPA 1788 of 2025 stands disposed of on the with the above observation.
Grateful.
I'm
I have,
always,
I have mentioned there that if there is bar of limitation, that will this representation consideration will not be used as
That I have followed.
Deeply blunt.
May it please. Everyday service. Now the extremely short point involved, Lord. Now I was having a one valid stall to have 24 square feet at the fish market area, Lord. Lord, initially it was a partnership firm. My partners, one of my the name which was recorded in the official record, Lord, he retired from the business. Now I am running the vehicle. Lord, in the process of developing the area, Lord, I was asked to remove the stall. I did that. Lord, then in order to run the regular business, Lord, the livelihood, I was asked to make a makeshift kiosk. So I did. Now, Lord, the KMDA after erection of the market, Lord, in order to clean up the area through inadvertence, my kiosks have also been dismantled. Now the thing is, series of representations. Please consider my prayer. Please consider my prayer. Give me a stall of only 20. Either panviris or tea stall. So till date, no consideration, no answer. You'll also will find from the series of letters itself.
But do you
And
have
the
a right
license
to
fee
have
which
stall there?
the license fee which
You have a right to have a stall over there.
yes, the official records will
Because
speak for itself.
consideration of representation.
Stall number is given 4K.
Where? Show me.
My lord,
Let him show the right. I find but yes, he's a complete stranger. No right was allotted to somebody else.
I say,
Let him show his right.
my lord, the retirement of partnership deed that I also can produce before.
Show the partnership or the license. You have to show that. The chain has to be established.
My lord, that is not the
Not a single stack of
rustic man.
right.
You'll also will find the entitlement of the stall.
License, he claims that she formed a partnership with him. Partnership became licensed, which is not permissible because partnership was not licensed. Then that lady retired, he becomes the
Not lady, Bindeswar Chaudhary. No, Bindeswar.
He becomes the by this way he becomes the partner and becomes the licensee. That is his claim. Allotment was
He died after retirement. He
So
died.
why are you not deciding his representation? Decide it and reject it. If he has made a representation, that can be said to him only, because instead of the writ court, because then I will have to decide whether he has a right or not. That can at the first instance be decided by the authorities themselves. If he has no right, he has no right. My direction, I'll make it clear that this direction of mine, as I did in the earlier matter, that this is not going to be taken as a commentary on his right.
They got one line of submission that contention of claim is that he has no right because it was never allotted.
Very well.
Now the KMJ is at the helm of affairs. Not initially it was HIT. So they ought to have considered the prayer.
Initially it was?
It was HIT. How improvement. Now the market has been entrusted to the KFB authority.
And what is it that you had under Howrah Improvement Trust? What is it that you had? What is the tenement that you had? Kiosk.
No, the license fees, receipts, everything is there.
No. What was the property that you were enjoying?
One stall number 4K.
He was not given the license. Somebody else.
No, that is the issue here. That is to be decided, my lord.
Who was issued the license?
My lord, the HIT. That point of
Who
time.
was in whose name?
Bindasa Chaudhary.
And how are you connected?
Well, I am the one of the partner. After the death of Bindasa, my lord, I am running this. My lord.
No, but it is in the name of the partnership firm or
Well,
name of
the
person?
record speaks. You also kindly take trouble to look to page 15 onwards.
Page 15, yes.
All carried out the name of Bindasa Chaudhary.
No, Bindeshwar Chaudhary
Stall number
is a
4K
person.
at 1 IC Bose Road. No, Bindeshwar go. Bindeshwar.
This page 26 not Bindeshwari.
That may have been wrong.
No, but Bindeshwar Chaudhary is a person. So how does it show that it is a partnership?
Not all the deeds are there. Not the original partnership deed. Thereafter the retirement deed. Not
You are one of the partners.
one of the partners.
So this license was issued in the name of the one of the partners
One of the partners.
for the purpose of the
So
partnership.
the old business not is standing in the name of Bindeshwar Chaudhary.
There is contention for was only Bindeshwar.
Very well. लिखे ली.
ऑन कर लो मैं कर वीडियो मत कीजिए सर जा रहा है तो जा रहा है ऐसे कर रहे हैं ऐसे मत कीजिए सर H-minus दिखा रहा है वो तो बोल रहा है किधर आपको आप वहाँ से चेक करिएगा, वहाँ से देखिएगा।
My lord, I am for Union of India in 291, my lord.
Yes.
My lord, this is a case like, my lord, a gentleman entered into a restaurant. He did eat nothing, but he will have to pay the fee. Charges. This is like that. I opted
Where
to.
is your application?
Well, page 39. I am writing to request the exemption of Basantu Society ESI coverage under several sections of the employees. References.
Directing them to consider and dispose of this
Yes,
representation.
yes.
Directing, consider and dispose of the application.
And who is appearing for the Employee State Insurance Corporation? Who is appearing for the Employee State Insurance
Yes, sir.
Corporation?
Yes, sir.
Employee, nobody is appearing.
Have we served?
No, employee.
You have not served them.
No, no, no.
You served them.
Oh.
लिखे दिन. Service on all the respondents is not yet complete. Full stop. The petitioner shall serve copies of the writ petition on all the non-appearing respondents within a week from date. Full stop.
All the non-appearing means, my lord.
Whoever is non-appearing, you have to serve all of them. You have made so many parties, you
Yes,
will not
yes.
serve on them.
Because they are
My lord, Union of India is appearing, my lord.
Very well, I have recorded your appearance.
My
Yes.
lord.
Serve copies of the
recovery officer.
the non-appearing respondents. Full stop. List within a week, and shall file affidavit of service to that effect on the returnable date. Full stop. List the writ petition for further list the writ petition once again on December 5, 2025. In the meantime, please serve.
Yes.
Yes.
My lord, I am grateful.
Union of India is represented. लिखे थे मैं.
Because main grievance is against the union risk.
No, against the ESI, they have to consider it. They have to be served, not Union of India.
I am grateful.
But 92 and 93.
Yes.
Similar matter.
So 293 the
Whether bank got the possession of the property later on. At last, we have also given representation to DCM.
who is appearing for the state? Why are you not considering it? You have to give them possession. That is the law. Page 27. Page 27. Yes.
After that, my lord, 30. So later dated 12. I don't see my lord bank made an application before the district magistrate.
You have not seen the report. There is an application addressed to the district magistrate on the bank's letter. Page 33 of the report file. You have seen the report. You have served a copy. No. You please give them a copy of the report. Page 33. You show them. Show them.
33.
Twenty-fourth of September 2025.
My lord.
This was made before the DM. There is a receipt.
Yeah.
Then
My lord, I have seen.
you file a report on the action taken on this. Because immediately you should hand over possession. You should take steps. That is the law.
My lord.
You are aware. There are judgments to that effect under section 14. You have to
Hand
execute.
over this, my lord, copy also, my lord. My lord, kindly, my lord, my learned friend, my lord.
You serve a copy on them.
I will instruction.
Then that should be done because section 14 application.
My lord, I checked out, my lord. I talked to my lord.
लिखे नहीं
My lord, Mr. Dutiman,
I am from the Union of India.
in this matter, my lord, he is engaged in courtroom hour 21. Can it be taken up at 1 p.m.? Matter is going on, my lord. He is engaged in 21.
Yes.
My lord, matter can be taken up at 1 p.m. My lord.
Just a
I'm
minute.
just praying.
Calcutta telephone cooperative.
Yes.
No supplementary every engagement.
My lord, I have
passed over.
Yes, get.
See,
My lord,
for
1
pass
PM.
over, let him come. Maybe he comes with it today.
Get.
1 p.m. In this matter, my lord, Mr. Hardor Manager is appearing. My lord, under these circumstances, I am paying for short passover. Short passover. He is on the legs.
Pass. Pass. Pass over.
I'm appearing for the state authority.
Well, the petitioner purchased some scheduled plot of land from two brothers. Thereafter, he was in possession and continuing with the possession the petitioner. One brother, my lord, made an application, made a writ petition before this Honorable High Court. On the basis of the order of the Honorable High Court, there is an inspection and etc.
Who is he?
Lordship, I am taking
I am-
the primary.
I am sir, defendant number 9 in this case. Vishwanath Dhori.
You are appearing in person.
Yes, sir.
Please stand here.
From whom I purchased land. And thereafter, he filed a writ petition before this Honorable High Court and obtained an order. Lords, can you see the order, page 30. It starts from page 36.
Yes.
Without it, third paragraph, my lord. An application paying for removal of the illegal encroachment is pending at the end of the respondency for a considerable period of time. Without entering into the merit of the said application, the state petition is disposed of, but directing the executive engineer, public prosecutor, government of West Bengal, being the etc. A spot inspection shall be conducted upon notice to all. Thereafter, my lord, a notice.
Please wait. Let him complete. Yes.
My lord, thereafter, my lord, lordship kindly see. A spot inspection was done, but there was no demarcation. Nothing has been said. Lordship kindly see the notice. Page 79, my lord.
Yes.
Kindly see. Spot inspection on ATO in connection with WPA number ATO in the matter of etc. With reference to above, this is to inform you that a spot inspection will be held at the site in connection with the WPA ATO in the matter of OMU passed by the Honorable High Court, Calcutta. In view of the above, you are hereby requested to present at the site on the scheduled date for spot inspection. There is no mentioning of spot. Kindly mark it. Which spot they will inspect it and which plot they will inspect, that has not been mentioned in the notice.
No, but if they have mentioned WPA, does it not give an indication of which plot? It is in respect of the plot in respect of which the writ petition was filed.
Hello, Lordship, kindly see.
Lordship, I am taking 1 point, Lordship.
Mr. Chatterjee, is this not an appealable order?
Appealable under section 10(4), Lordship.
My lord, I am
Why
coming.
should writ petition
My
be
lord, I am
executed?
coming. Why I have come before your lordship? It's a gross illegality. That's why I have.
But these points can be taken before
My
the
lordship, kindly-
appellate authority also. Why
Ki-
writ petition? Unnecessary.
Kindly see. Thereafter, my lord, lordship, we immediately made
Mr. Chatterjee,
objection.
prefer appeal. I am sending you to the appellate authority. I'll ask them to consider the appeal and dispose it of within a specific time frame. That will do, because there is an appellate authority. I will be entertaining writ petition. Why?
10(4), your Lordship.
Listening.
But delay may be condoned for.
Yes, yes. Prefer appeal. What is the time for preferring appeal? 1 month.
15 months. 15 days.
15 days. That's why.
Under section 10(4), Lordship.
My lord,
And
affidavit
is there
service be kept on.
Is there a provision for condonation?
There is no such.
No, there is no such provision. That's why, my lord, I am praying before your lordship.
Number 9. Vishwanath Dhori, I want to say something.
Yes.
Thank you, my lord. My lord, I am defendant number 9 in this case, and may I proceed with legal points of law only my side with proper documents. Please, sir, take this.
Please wait. I am not hearing this.
Yes, sir.
I am not hearing the writ petition now. The writ petitioner has a remedy before the appellate authority. Against the order, he can prefer appeal before the district magistrate. I am sending him back there. You go and argue there. This writ petition is not maintainable here.
Sir, just on the door.
দেখি উনি দিতে চাইছেন একটু দেখে নি কি আছে
আমাদের একটা কপি
ওনাকে কপি দিন একটা
এটা আমার কোনটা দেবেন এটা ফাইল করেছেন
ঠিক আছে এগুলো তো আপনার মেরিটে আছে আপনি ডিএম এর কাছে ওনাকে পাঠিয়ে দিচ্ছি অ্যাপিলে যাবেন ওখানে আপনি গিয়ে বলবেন এটা এখানে আমি এই রিট পিটিশনটা এন্টারটেইন করছি না তাই বলছি আমিও তাই বলছি থ্যাংক ইউ this writ petition
It is not your writ petition. You cannot ask any prayer, made any prayer before this court. I am grateful, my lord.
Next. Thank you.
Yes, I'm for the appellant, my lord.
Yes.
I use the affidavit of service.
But I'm for issue number 3. Raising a maintainability point, Lord, it's in the writ petition, an order passed by the National Commission has been challenged, which is an appealable order. The act provides for an appeal provision.
There's a judgment I'm relying upon.
That is the maintainability point I am raising at the moment. There is an alternative remedy, statutory alternative remedy available to the petitioner.
Without two cans.
Without bringing any party under the Article 12. There is no entity which is framed under Article 12 in the writ petition. Whether such a writ petition is maintainable or not. That's the.
Let's decide the two cans first.
All parties are private parties. All the parties are private. The 3 respondents, all of them are private respondents.
I have 2 Supreme Court. I will show that.
No, they have a different point. If this
Yes.
was a proceeding under Article 227, then this point would not have arisen. They are taking this point because, see, if you see the cause title, the respondents are all private persons. You have seen the respondents?
Yes.
1, 2, and 3.
Yes.
All 3 respondents are private persons. A writ is maintainable only against an Article 12 authority. That is their point.
But Supreme Court said, I will show that. 226 or 227.
Yes,
This is the
so
only forum.
you have to array somebody as a party here who has the Article 12 character. Otherwise,
Like a government, but
yes, otherwise, instead of 226, you have to file a 227.
But Supreme Court said either 226 or 227.
Yes, 226, then Article 12 authority has to be here. Against a private person, I cannot entertain a writ petition. Against a private person, I cannot entertain a writ petition.
I can come there after the 2 cans decided. Whether I can argue, that's the can 2.
No, that is different. That can be allowed. You can argue.
Okay.
But then the writ petition can be entertained only if it is against an Article 12 authority. You can withdraw this and file
227.
File 227.
If that's the case, then just pass an order like that. I will file it again.
Yes,
and the only thing is, Your Honor knows, I am here, and because the video thing is problem, even from US, that's why.
Instead, let him add National Commission as a party, and then
that is his choice. I'm saying as on these days, as on the papers that are available for the court.
National Commission.
But even then, I have to National Commission. I can make. But that's not Supreme Court said. I have 2 exact same thing, right? Went from National Commission to the 2 on paragraph 5. I have annexed in the main writ.
Yes.
Paragraph 5, page 4. So that's what I cited. I have annexed both the judgments. In Ibrat Faizan, this is 2023.
Page?
Page 4 of the appeal, of the writ petition.
Page 4 of the writ petition.
Yeah, paragraph 5. It says,
yes.
So it says the judgment dated which is annexed herewith, marked annexed P1. Okay. The instant writ petition filed against the impugned final order judgment passed by NCDRC as the Honorable Supreme Court in Ibrat Faizan versus Omaxi and Universal Sompo versus General Insurance has categorically held appeals against learned NCDRC order in cases filed under section 58(1)(a)(3) and 51(1)(a)(4) of CPA, Consumer Protection Act, would be before the appropriate jurisdictional high court. So that is why. And those 2 I have annexed. I can take you through that. And there they say it can be filed either 226 or 227. Either or.
Yes, but for 226, there is an additional criteria that it has to be directed against
the government authority, state authority,
Yes.
But this is a unique situation, and that's why Supreme Court said so. I thought so too, but Your Honor, I can just make it 227. But that's such a technical thing, and I did it only because of the Supreme Court said so in 2 judgments, very recent judgments. Yeah. Your Honor, in the appeal, original appeal, front page, the cause title, if you see the appeal, Your Honor, kindly have a look. I was very aware about this. Original appeal, the first page, the cause title, I said 226/227. See the cause title in the appeal?
Yes, but 227, I don't have jurisdiction. That is the problem.
So that is why I kept 226 by virtue of 2 apex court recent decisions. Because this came. So I am, both these judgments, they said this, that it could be filed. And then the Delhi High Court recently, which I haven't brought, I can bring it next day. Exact same thing. They say, no, you can file, we will hear.
Delhi High Court is hearing. That's another case which is not here.
Actually, different courts have different rules. In some courts, 226/227 is permissible.
Yeah.
In our High Court, we have 226 separate, 227 separate. This combined 226 to 27 petitions are not entertained in Calcutta.
It is a rare thing, not entertained, but
it is there in Allahabad, it is
Since-
there in Delhi, but I don't think Chennai also doesn't.
That doesn't follow. Delhi doesn't follow. In fact, Bombay High Court also doesn't follow.
Both are
Chartered
not
High
permitted.
Your Honor, kindly come to page 144. I have annexed the Supreme Court judgment, the one I mentioned. And the head note, I'm just seeing the head note here. On page 144, it is the Universal Sompo versus Suresh Chand
Yes,
Jain.
yes, I agree with you absolutely. This I have also noticed
And-
this. I've
and
seen
this-
this. I've read this. I don't say that 226 is not maintainable, but the format in which it is presented may not make it convenient for the court to accept it as a 226 petition. You get my point? Because 226
Then I have to go back to Supreme Court, I guess.
226
But-
petition. 226 petition is
Oh,
why
my
you
lord,
amend
I am here for that.
you amend
When-
the cost title and implead the
So that would be bigger problem because NCDRC, that has not happened. That to make them a party and then the service. No, instead of that, if your Honor feels, I will just make it only 227. I remove the 226.
227 will
Both the judgment that my learned friend is referring to are cases where the appeal was not maintainable for the Supreme Court because the Supreme Court did not have jurisdiction to deal with those cases.
No, no.
Not all consumer protection cases can go up to Supreme
No,
Court.
no, it only goes. You read this, they specifically say you have to go to High Court.
So, my lord, the sections that are mentioned in the judgments are 58(1)(a)(1). Only in those cases, because Supreme Court does not have jurisdiction to deal with those, they can come before
Supreme
these.
Court has jurisdiction to deal with those cases only if the case has originally been filed before the National
National
Commission.
Commission, yes.
Then in that case, against the Supreme Court, you can go under appeal
Right,
provision.
right.
But if the remedy
travels from
for-
the-
if,
yes.
if you have approached the National Consumer Forum by way of a 3-tier remedy, say consumer
From the
consumer
state,
forum,
from the
then
state.
Yes.
then in that case, Supreme Court
Then
you
Supreme
cannot
Court
go
will not have
directly.
jurisdiction.
You
So I have to go to High Court.
You have to come to the High Court
Jurisdiction
under
of High
Article
Court?
226 or
And that's-
227 and then to Supreme Court. So
Yes.
This case is falling under that.
Now he has to come by adding up my lord has already observed
Yes.
Article 12 authority
Article
Article
12
12
authority must be there,
or civil revision as he feels. my lord.
or 227. That is the
Yes.
prima facie view.
227 will be the simplest way. So if your lordship then just make some comment, I will file this week and have it heard next week at least because Your Honor, the-
227. Next week you will be here available.
yeah, I will be.
Let
No,
me
I
also
came
think
for
of
this. This is a
what
major thing.
modality will, because this is specially assigned now.
Lordship is giving you the liberty.
No, no.
I understand. But
He's appearing in
No,
person.
No, they have
But
given,
this
even
is what is
Supreme Court
personal
given
case.
me
He's
this level.
appearing in person and
Well, that's also
And
a
I'm
point that
doing
I
pro
raised.
bono, Your Honor.
Yes.
I've come here.
I also raised that issue last day. Lordship told me not to take because
yes,
it's not his
last occasion.
personal.
No. He is appearing in person.
That is the reason I didn't
and
argue
he is
that point.
before court of law. So instead of going into technicalities,
I
we
will
have
not.
to address the problem.
Yes,
So
that's
let me
all.
also think of it if it can be addressed here at this level. Then in that case, we'll finish it off and we'll go into the merits.
Absolutely.
Whatever the
Yes,
problem
yes.
is, we'll hear it out.
Yes.
Or if he has to change, then I will grant him liberty to change, and so that this limitation thing does not
Yes.
come into picture again, because it has been pending here for quite some
So you
time.
can dispose of can 1 so that I can even say here and can 2.
Point 2
I
is
Can
will
one-
dispose of all of them on the same day. Once I assume jurisdiction, I will dispose of all of them because my
Okay.
jurisdiction is dependent on this. Let me also think of this because this is a unique situation.
Very
the point
unique.
which-
I
the point
understand.
which he has taken,
And if Your Honor wants, I can bring the Delhi High Court judgment, which is even
that
for this.
will not help because rules might be different.
Yeah.
Rules might be
But
different.
at least
I will also apply
collaborate.
my mind. Likhen in.
My lord, I am appearing on behalf of respondent number 1, my lord. Kindly record my appearance, my lord.
Respondent number 1. Already.
My lord, my lord.
A point as regards maintainability of the writ petition has been taken by the respondent number 3.
all the
Full
response.
stop.
As well as the respondent number.
Acha, by the respondents. Full stop. It is submitted that this application has been styled as an application under Article 226/227 of the Constitution of India, full stop. The full stop, a writ petition under Article 226 can only be maintained against an Article 12 entity, against a person or an authority satisfying the definition of Article 12 of the Constitution of India, full stop. List this matter for further consideration on 28th.
Yes.
28th. You also, not as an adversary, but
No, I
as an amicus, you also study, I will also study. Let us come back with this, because this problem, it should be solved. If we can come up with some solutions, then in that case, we'll address the merits instead
Yes,
of beating
yes,
about the
yes.
bush, because this problem will arise every time.
Whenever this issue of Supreme
Yes.
Court, not availability of Supreme Court forum.
Yes, this will arise.
Somebody has
So let us address this.
Yeah. And then I will also, the Delhi High Court observation. I will
So on
make
28th, I am keeping it.
28. So I will amend, but
Lordship
you
is
know,
58, Lordship
I
is
will
58,
amend that was title to 226.
Not now.
227.
Not now. Let us come back on the next day, then I shall grant leave if required.
And next day, then it will be argued on what?
On the same point.
On the maintainability or merit?
Maintainability.
Maintainability.
Maintainability has to be decided first, then only we can move to merits.
Yes. So, but if I withdraw this and file it under 227, then their objection.
No, then their objection goes.
Don't have any objection.
Then their objection.
So
But this
can we
court
do that? Because that will save time. Otherwise, it won't be decided on merit on the same day. So
No, if I entertain, then it will be decided on merit on the same day. If I don't
will
entertain,
want time to file objection, all these things. You know,
objection.
So for my situation, so why don't I withdraw this and refile as 227 and fix it next week?
Very well.
Otherwise, merit they won't go on merit, and that's all I
very
want.
well. Very well. लिखे नहीं निकले.
And they have no objection. They said
He withdraws this application and files an application under 227. Then, madam, the admission will be, perhaps this party, there is no KVL to that. Move that 227 application please to us because we have implemented this. That is the problem which we will be facing in an application under 227.
I don't understand.
No, they are talking about a technicality.
Yes.
In
Understand that.
226, whenever a 226 petition is filed, you have to give a 48-hour notice before filing, unless there is extreme urgency and you have prayed for dispensation of that notice. In a 227 petition, they will not give advance notice unless they file a caveat.
I filed advance today, I mean, this week. So why they won't get
that
it?
undertaking period.
Your Honor, this is getting too and you want to understand what is happening here. They know I cannot be here for too long. This is not right.
No, I'm only
This
saying
for
let him just
justice, I have
undertake that
to
you will
plead
serve
for
upon us and move.
even law can be broken for justice. My lord, and what is happening here? You are not seeing it. So I will serve them advance. ago in National Commission. Their video would not work, so I had to travel to Delhi. I'm trying to help you on that. So I will be here, no matter what case I have. Grateful.
Thank you. I'll come back in 5 minutes.
for the state lodging.
And for the petition.
Yes.
Well, I appear in this matter. But after going through the brief, I have, my lord, seen nothing in this matter. Better, my lord, leave may be granted to the petitioner to file a comprehensive application before the authority. What, my lord, he did not get after the appeal was disposed of by the commission. Here I find that initially the SPO was not imposed 25,000 cost for not giving the information. Thereafter appeal, my lord, heard and disposed of page 96, my lord.
Yes.
Here, my lord, I find that the information was given, but yet the petitioner cases, he has not received all information. Better, my lord, give me liberty to file an application, a comprehensive application before the authority concerned, and that can be discussed of. Nothing is there, my lord. My lord,
Basically, the petition
I'm very fair, my lord.
some land area regarding which he wanted some information. His allegation is that he has been constantly sending RTI requests and nothing is being attended. However, I have a report for your lordship. If lordship will go through the report, the lordship will find that at every instance, every information was supplied to him. He also filed a case in the commission regarding this RTI thing. And if lordship will come to the last order, which is in page 19, annexure 9 of the report,
Yes.
then lordship will find the facts, the records and findings of the West Bengal Information Commission, that order.
That is admitted, my lord.
So
I
there is
find, my lord,
nothing
no
in this
substance,
case.
my lord.
There is no substance in this case.
I am very fair, my lord.
So what liberty? Liberty is not required from writ court. If you have law, a right in law, you file application.
If any grievances, my
No
lord,
leave. Unnecessarily, why leave? By way of filing writ petition. Very well. लिखे
say for the petitioner. The petitioner was.
This is my.
Yes. But the fact of the case is that the petitioner was arrested in connection with Kotwali PS case number in the district Paschim Midnapur for Maoist activity. And my lord, she was charge sheeted against that Maoist activities, and subsequently, my lord, she was released, and thereafter, my lord, she was acquitted. And on the basis of the adopted policy taken by the government of West Bengal, to my lord notification which will appear, my lord, kindly see the a report filed by my learned friend, the notification report in the form of affidavit. Kindly see the notification at page 21. In that report.
Yes.
In this notification, my lord, the government will provide a lump sum job to the persons who has already surrendered and connected with Maoist activities. My lord, in their affidavit in form and report, kindly see the page 70. Page 70. Page 70 of the report. My lord, two persons who were arrested and on the same footing of the Maoist activities were engaged in job. But my lord, here, though the petitioner was charge sheeted and on the same footing, she was not provided any kind of employment as per notification adopted by the government of West Bengal. My lord, kindly see page 52. These two persons, page 52 of the report, my lord, these two persons, they were directly connected with the same case, PS case, and my lord, they were provided the employment as a linkment of the Maoist, linkment of the Maoist. And here the petitioner is, my lord, the member of Maoist squad, and she was, my lord, on the same offense was arrested, my lord, and all these accused persons arrested in connection with the same police case, my lord, they were acquitted because of, my lord, government has not taken properly step, my lord, so far as the government has adopted the policy that if the member of the Maoist square surrender or arrested in connection with their, my lord, activities regarding prevention of damage to public property and, my lord, maintenance of the Public Order Act, my lord, they must be employed by that notification. Here, my lord, only, my lord, discriminatory activities on the part of the respondent authorities, though the petitioner pays for, my lord, her engagement regarding my lord, any kind of job, either, my lord, NVA, National Volunteer Post, Home Guard, or, my lord, any kind of, my lord, contractual job. Here, my lord, this is nothing but discrimination on the part of the respondent, my lord, police officer. The superintendent of police, my lord, is directed, my lord, to provide the employment as per notification. Kindly see that notification, page 21. That is, my lord, in the report in affidavit of form submitted by the respondents, my lord. This is, my lord, purely violation of the Article 16 of the Constitution of India, purely discriminatory activity.
Lord, if your lordship kindly takes, my lord, page 5 of my report, paragraph Roman 6, my lord, I have explained, my lord, the revised guideline of the government of India, my lord, Ministry of Home Affairs. Has your lordship got page 5, my lord?
Yes.
Roman 6. Here, your lordship would find here a revised guideline of Ministry of Home Affairs, Naxal Management Division, and, my lord, detailed guidelines has been, my lord, explained, my lord. And if your lordship turns to page 6, my lord, subparagraph A, your lordship kindly sees these guidelines are applicable to those LWE left wing extremists, my lord, cadres who surrender with or without arms. Has your lordship got it? Kindly. Thereafter, your lordship kindly sees, my lord, a specific FIR was registered, my lord, against my learned friend's client along with other persons. Charge sheet was submitted. Thereafter, she got acquitted. And if your lordship kindly takes, my lord, page 12 of my report, paragraph Roman 7, my lord, your lordship would be pleased to find that, my lord, in terms of the said my lord, guidelines of the central government, Ministry of Homes, subsequently a notification, may I read, my lord? Subsequently, one notification was received, video memo number such and such, from the office of the Joint Secretary to the Government of West Bengal, Home Department, November such and such. This notification, in accordance with the revised guidelines, which I have, my lord, already explained to your lordship, issued by the division for the surrender and rehabilitation of Naxalites under the security related expenditure scheme or any other surrender scheme framed by the state government for this purpose, and in consideration of the facts and circumstances, the governor has been pleased to revise then existing incentives under this scheme and make the following changes to the scheme notified with such and such for providing gainful employment and entrepreneurial opportunities to the surrendered Naxalites and to encourage them to join the mainstream. This is the revised guideline, and kindly takes me page 13, first two bullet points. The scheme is applicable to those Naxalites, Maoists who surrender with or without arms. The second is, my lord, the eligibility of such Naxalites, Maoists for assistance under the scheme would be scrutinized, which is very important, my lord, by the screening committee as constituted by the state of West Bengal, to be headed by the surrender cum rehabilitation officer. Then your lordships kindly takes, my lord, page 14, last bullet point. Has your lordship got it? Page 14,
Yes,
last
yes.
bullet point. The screening committee must ensure that the surrenderee is a genuine Naxalite, Maoist, and the surrenderee should make a clear confession of all the criminal acts committed by him, her, including names of the planners and other participants, name of the financer, harbor couriers, details of Naxalites, Maoist organization, arms, ammunition, property looted, disturbed, disposed of by Naxalite, Maoist, and organization to which the surrenderee belongs, which will be subjected to due verification. Thereafter, my lord, the surrender of Naxalite Maoists should be confined to the alarm squad members and above other ranks and overground supporters. The screening committee shall record reasons in writing for accepting or otherwise the proposal for provisional surrender. If the proposal is rejected by the screening committee, the surrenderee shall undergo due process of law. A surrenderee shall undergo due process of law, shall give a written undertaking regarding his willingness to surrender and undergo the revelation process as defined in the policy. No surrenderee shall be subject to revelation without the express agreement. Thereafter, my lord, kindly takes, my lord, page 16. Middle portion of the page 16, sentence starts after perusal. Has your lordship got it, my lord?
Yes.
After perusal of the said memo, it came to learn that the government of West Bengal decided to enroll 220 ex-Maoist linkmen in 4 districts of West Bengal, namely such and such districts. It was directed in the said memo that to enroll 220 extremists by way of special dispensation Home Department. Thereafter, memos were explained. Relevant is page 17. Second paragraph. Ultimate paragraph, page 17. It is also to be mentioned here that not all the charge-sheeted persons or FIN persons running cases were enrolled as Home Guard. On the basis of the intelligence input, this is very important, my lord. On the basis of the intelligence input received from local PS as well as district intelligence branch, persons who were previously involved in LWB activities through crime, offence against state, subservice act, activities against the security forces were duly surrendered before the authority concerned. Thereafter, the proposal sent to the screening committee. In regards to the matters of petitioner Aloka Manna, after she got acquittal from the Court of London Additional District Sessions Judge, 4th Court, Paschim Midnapur, such and such date in connection with such and such case, no such local input was collected about her direct involvement with LWB activities through crime, offences against state, subversive activities against the security forces. So her prayer for job under the government scheme was not considered. That memo is annexed below. Thereafter, your lordship kindly takes paragraph 9, Roman 9, middle portion, the sentence starts on 16th September 2010. Has your lordship got it? Sentence starts?
Yes.
The petitioner, along with other accused persons, got acquitted from the court of learned additional discharge such and such. After that, no such intelligence input collected from the local police station or district intelligence branch regarding the petitioner's direct involvement with the left-wing extremist activities through crime offense against state activities, against the security forces. Therefore, the petitioner's prayer for job for surrender and evaluation scheme of the left-wing activities in the affected states or such government scheme was not considered. So, Milord, details inquiry has been conducted, Milord. A screening committee was formed in Milord, terms of the guideline, Milord. They investigated, they inquired into and found, Milord, she has not connected with any extremist activities. That's why, Milord, she has not been provided with the benefits attached to this scheme. This is the detailed report, Milord.
My lord, kindly come to the page 22 of the writ petition. Page 22 of the writ petition.
Page 22.
Page 22 of the writ petition.
Yes.
My lord, paragraph number 3. This is, my lord, charge sheet submitted by the police officer against Oloka Manna and all other accused in connection with the same case, same Kotwali PS case. My lord, I am reading that. During investigation of this case, myself, I draw up a rough sketch map of the place of occurrence, PO, and made it index, examined injured police persons and available witness marked their statement under section 161 CRPC. Seized the weapons under proper seizure, last duly signed by the witness. During investigation of the case, it reveals that some members of Maoists were arrested by joint force of Chandra. Then, my lord, she was arrested at the spot, at the place of occurrence, and she was taken into the police custody, and she suffered the jail custody. After long suffering, my lord, she was released from the jail custody. Then, my lord, kindly come to the page 17 of the report, which my learned friend submitted before your lordship. Page 17. My lord, this is the same Kotwali PS case. My lord, I am reading from page 16, last lines.
Page of the report, which page?
Page 16. Page 16. My lord, kindly come to the memo. One notification was also last 4 lines at the bottom. Memo 1 notification was also received at the office by number 2012 PL/PB 14M 161 and 16 PT dated 31st July 2021. In the notification, it was mentioned that in Paschim Midnapur district, 104 male and 6 female, total 110 persons were selected for the job of home guard volunteers under government scheme. But in the list attached with the said notification, serial number 105, but that is Sokha Ruidas. That is Sokha Ruidas. Sokha Ruidas. He is one of the accused. And my lord, Urmila Hasda. She was one of the accused of the same case. Then, my lord, kindly come to the page 16 of the writ petition. Page 16 of the writ petition. Sokha Ruidas, accused number 1, bottom, at the bottom of the page. Sokha alias Sokha Ruidas, son of Asutosh Das of Chandra. Then, my lord, kindly come to the page 18. Accused number 10, Urmila Hasda, wife of Dhananjoy of Chilgoda. But they were provided employment in connection with the same police case.
But there were many others who were not provided.
No, my lord, this is not proper. No inquiry was held regarding her involvement as the member of Maoist Squad. My lord, report is not proper, according to me, according to the instruction of my client. Because of my lord, so many persons were provided employment. My
No,
lord,
but the report says that all the FIR named persons were not provided jobs. That is the report which is that
My
is
lord,
what the report is saying.
this is not their case.
Yes,
This
it is
is
their
their
case.
case, my lord. Kindly see. Kindly see. That is at page 17.
Kindly see page 17, second paragraph. Page
My
17.
lord, the respondent here now whispering that he was not involved in that case.
No,
He
no.
was not
Second paragraph.
Maoist activities.
Please read second paragraph, first line.
It is also to be page 17.
Yes.
It is also to be mentioned here that not all the charge-sheeted persons or FIR named person in running cases were enrolled as home guard.
Yes.
But several persons were not connected with Maoist activities were employed with several jobs, several kind of jobs. Here only home guard. Kindly see here it is stated only to the post of home guard. But there are so many other posts, civic volunteer police force, national volunteer force, and also other government jobs. But this is with regard to only home guard. These two persons were appointed only to the post of home guard. But it is not properly whispered how many persons were employed against the government job, total government job. According to that notification, it is whispered only 209 persons. They are provided employment to the post of home guard.
You take an exception to this report then.
He has already filed.
Where?
I have already.
Show me. I don't have a copy of that.
Milord, it's a government policy, Milord, policy decision.
No, policy, it cannot be discriminatory. Policy
Yes,
is
my
right.
grateful.
No interference with the policy.
He has not been discriminated, Milord.
if on
Your
the
Lordship
basis
has
of the
found in the
policy,
policy itself that there is a screening committee. Screening committee, Milord, inquired into and found but that, Milord, she was not connected with any, Milord, LW activities.
Where is that
This
screening
can't be
committee's
said.
finding here?
Milord,
no, where is that screening committee's finding here in the report? That is an averment in the petition.
No,
Is there any document in support of
yes,
that?
yes.
Show me.
R4. Milord, first, your Lordship kindly takes to page 20.
Page 20.
Has your Lordship got it, Milord? Milord, second paragraph. During local inquiry, it came to know that on 20th September 2009 at noon, the then police team of such and such went to the Chandagam to work out the information that more than 100 villagers had gathered near Chandagam with deadly weapons with a view to attack the camp. After arrival, they found that about such and such persons, including female, had out the Chandagam armed with weapons, being requested to disperse. The villagers did not pay any heed. Later, they started pelting stones, aiming police, causing injuries. Last paragraph, Milord. During inquiry, it came to learn that the writ petitioner might be with the villagers who gathered at the Chandagam, but her direct involvement with the Maoist movement was not found. Now she is peacefully living with her family at such and such village. That has been, Milord, diarized. Thereafter, Milord, your Lordship kindly comes. কোথায় গেল? কেন থাকবে? R4 কি আছে? Milord, that was the inquiry has been in terms of the policy decision of the government, Milord.
But this is by the OC.
Yes. Yes.
You said screening committee. Where
Screening committee considered his opinion.
Where? Show me the screening committee's consideration. You said screening committee has to do it. That is the notification you said.
My lord, kindly see the page 20. My humble submission is, my lord, writ petition is filed on 5th February 2025. 4th February
My lord,
2025.
in
Writ
terms
petition
of
is
the,
filed.
my lord, if
Kindly,
your
kindly
lordship,
allow me
yes,
to make
yes, yes.
only
bolun
few
na,
lines.
bolun
To
na.
make submission only few lines. My lord, writ petition is filed on 4th February 2025. My lord, copy of the writ petition was served upon the my lord government leader. And after receiving that copy, my lord, kindly see the extract copy of GD number 457 dated 11 February 2025. My lord, incident took place in the year 2009. My lord, after 2009, how many years, my lord? I am asking myself. 2009, 2010, 15, 16 years. After 16 years, an OC is appointed to investigate her involvement regarding that my activities. But is it possible? But I am asking myself that it is not possible to make investigation after 16 years regarding Maoist activities of a housewife. Well, she was directly connected with Maoist squad. It is reported and it is charge-sheeted in the PS case. And all the accused persons who were connected with the same PS case, they were acquitted because of government has not properly taken step to convict them. Because of by this notification, the government adopted the policy to provide the employment to those persons who are directly connected with the Naxalist squad and Maoist squad. She was very poor
Where
lady.
is your exception? This.
Paragraph 5, 6 and 7. My lord, this is purely discriminatory and my lord, this report is not believable in the eye of the law. Page 20 of the report.
Yes, Mr. Mitra, what is your answer to this?
Lord, my answer
you
has
see
been
this. You see this page 20.
page 20, my lord.
Page 20 is the extract copy of a GD entry
Yes.
done on 11th of February 2025.
Yes. No input was received. That's
So
why
2025 screening committee will not be after filing of the writ petition. Screening committee's business will be before filing of the writ petition because he is aggrieved.
Yes.
Writ petition was filed in February 2025.
Lordship,
That
my
is
lord.
his allegation.
Yes.
His allegation in paragraph 6 of the exception is exactly that this is an afterthought.
Grateful to my lord.
Screening committee's job was before the writ petition.
Well, nothing has been done.
Grateful. My lord, what happened in this case, your lordship kindly considers, my lord, paragraph page 17.
Page 17 of?
Page 17 of my, my lord, exception. Report, my lord.
Report. Page 17.
Sentence starts in regards. My lord, I have shown before your lordship the inputs, my lord, general diary, my lord, which has been made by the my lord, local police officer that he has no direct involvement with the LWB activities.
No,
And
that was of 11th of February 2025.
Kindly sees, my lord, sentence starts in regards of categorical in this matter manner. In regards to the matter of the writ petition, after she got acquittal from such and such court, in connection with such and such case, no such local input was collected about a direct involvement with the LW activities. This is our categorical decision, my lord. No such input was collected.
But this is after filing of the writ petition. Now,
No, my lord. Kindly R4. R4. My lord, his online application is at page 26 of your writ petition, and my lord, that has been disposed of.
Page 26.
Yes, page 26 of the writ petition. Date of grievance, has your lordship got it, my lord? Date of grievance, page 23, page 26.
Yes.
22nd September 2023.
Yes.
Aloka Manna, employment plan, grievance status disposed of. In 2024, my lord.
Milord, after waiting, Milord, considerable period, Milord, he came up before this honorable court. And Milord, we are very categorical in our stand, and we have specifically stated no such input was received. There is a policy decision of the government, Milord. In terms of the policy decision, Milord.
Why was your grievance raised in 2023? You were acquitted in 2010. When did your amnesty scheme come into force?
In 2013, Milord, it's central government's scheme. Milord, it has been revised by the state government, and new scheme has been floated by the state government. Milord, 5th December 2013.
So if the scheme was of 2013, in 2023 you start making application that
My lord, in
I should be
20
considered.
Our case was registered in 2009.
My lord, kindly see 22nd September 2023. This is a report, my lord, sent by the police officer to the writ petitioner.
Yes.
But no hearing was done. Nothing.
When did you apply? Your application is of 22nd of September 2023.
My lord, after notification.
Notification was of 2013.
31st July 2021. Kindly
Where?
come to the page 35.
Page
of the
35.
report.
কোথায় আছে পলিসি, কোন জায়গাটা পলিসি কোথায় কোথায় আছে সেটা ভাগ করো, পলিসি কোথায় আছে?
Well, after this notification, she has applied.
Yes, Lord. Notification is dated 31st of July 2021.
Yes.
Page 35 of the writ petition. Page 35.
Lordship, Lord.
Page 35 of the report.
Yes. Lord, kindly takes, Lord, the policy. It's the policy decision of the Central Ministry of Home.
Where?
Lord, kindly takes page 9
of
my report. Lord, one thing, Lord, I am told, I am instructed, Lord, if we get any input, then it would go to the screening committee. If we don't get any input, then Lord, it will not go to the screening committee. And that has been explained in our Lord, report. And kindly see these parameters for screening procedure. The LW have page 9, your Lordship got it, Lord?
Yes.
Page 9. Lord, page 8, Lord, page 8. Ultimate paragraph. May I place, Lord? A LW cadre shall be free to surrender before any unit of this CPFs, district magistrate, the district SP, the range DIG, the IG. The officers for this purpose shall be notified by the state government. A LW cadre may also surrender before such and such person. The officer receiving the surrendery shall send the details as informed by the surrendery filled up in prescribed pro forma to the SLR officer will get the antecedents of the kindly, I am attaching importance the word antecedents of the LW card.
No, but these are in respect of surrenders.
Surrender.
He was not a surrenderer.
Yes.
The writ petitioner was not a surrenderer.
No,
He was arrested.
So
he got acquitted.
He was arrested.
Maybe.
So this is not relevant.
No. Lord, kindly see parameters of this screening procedure.
But these are for surrenders. Surrenderies.
The parameters for screening procedure. Lord, kindly see the LW card. This is.
But this screening committee, this thing is going to apply only in cases of surrender. This is not a case of surrender.
No,
So
this is not a case of surrender. A specific FIR was registered. She got a charge sheet was filed. She got
arrest.
Thereafter, for providing him benefits, Lord, if at all she is entitled to, Milord, we have collected inputs, we have inquired into, and that has been, Milord, upon inquiry, it is detected that she was not connected with any
No, but
activities of the
in
LWB.
2023, you disposed of the
Lordship.
petitioner's representation
Yes.
on the basis of what inquiry? Where is that inquiry? In the inquiry which you are now relying on is of 2025.
Lordship.
Before the 2025 inquiry, you have disposed of the representation in 2023. Then 2023 is on the basis of what inquiry? The petitioner's application was disposed of in on 2nd of April 2024, it appears.
Lordship.
Now, the inquiry which you have conducted appears to have been done on 11th of February 2025.
Yes.
So what is the basis of this?
Basis, Milord, I have categorically stated in page 17, Milord, last paragraph, the sentence starts on the basis of the intelligence input.
This is of 2025, sir. The intelligence input which you are saying.
No, Milord, kindly sees on the basis of the intelligence input received from local PSS as well as district intelligence branch. Persons who were previously involved in LW activities through crime offense against against the security forces were duly surrendered before the authority. Thereof, the proposal sent to the screening committee in regards to the matter of the writ petitioner.
So this becomes arbitrary. How will a person
After
know
she got
before the
acquittal,
receipt
kindly
how
see,
you got-
after she got acquittal from the court of landed additional district judge sessions of Court Paschim Bidapur in connection with such and such cases, no such local input was collected, Milord. Kindly see page 18. No local input was collected about her direct involvement. Page 18. We are very categorical in our report. We have no such local input was collected about her direct involvement with the LW activities.
This page 26 is incomplete. Where is the next page? The sentence is incomplete of your writ petition.
No, only this has been sent.
No. Mr. Mitra, can you get the order by which this grievance of the petitioner, because this might give a picture. We don't have this. Page 26 is not complete. It is incomplete. Can we read at the bottom?
Yes.
The caller said that the CMO announced in press conference.
I shall
that
try.
those
I
and
will ask my
thereafter-
officers to give you a better copy.
No, better copy. No, you have to give, because he has taken a screenshot and taken a printout.
Yes, I will
This
come
is
up
what
with
it
that.
appears. So, what was the grievance description?
I would come up with
The remarks are also incomplete.
Yes.
The remarks are also incomplete.
Yes. Yes.
My lord, I am asking myself, my lord, in page 17 of the report, the respondent admitted that 2 persons were provided employment.
Sir, 2 persons might have provided, might have not. It is not that easy, because how will the court believe what you have said? Merely because you have arrested does not mean that you are also a member of the Maoist gang, because there can be substance in what they are submitting also. I cannot close eye to that. Somebody who was standing there in the group might have been arrested on the ground of suspicion. Charge sheet has been, ultimately you have been acquitted. So you
Yes.
cannot go fall back on the charge sheet saying that these are the charges framed, therefore I am a Maoist member.
Yes.
That will not do. There has to be clear cut proof. This is a writ court. I have to proceed on the basis of what is reasonable. Now this does not appear to be absolutely unreasonable. Their stand does not appear to be absolutely unreasonable. Unless there is something which pricks the conscience of the court, I will not be able to decide this on the
Yes,
basis
ma'am.
of whatever little I have.
Grateful.
Because it is oath versus oath. You say something on oath, the other person says something on oath. How will I sift the grain from chaff? It's difficult. You please bring this at least. Let us see what can be done. I am trying to reach to the truth.
Yes, yes.
It
Lord,
will
my
ultimately
argument
depend
is
on
referring his
whatever is there
161
before the court
statement.
in form of
161
material.
statement. He is Landesman's client is referring his
That
her
is in the year
161
2009.
statement. 161 statement.
What?
That I
161.
understand.
Bring all those records.
Yeah.
Today.
Heard learned advocates appearing for
My lord, I beg to appear on behalf of the petitioner, my lord.
Yes.
The petitioner is a developing company, my lord.
Yes.
He has developed a project of 5 buildings. My lord, while developing all this, the project was approved by several banks, including the State Bank of India. Now, some of the customers who intended buyers has taken loan from State Bank of India. Later on, these persons said that they will not buy the flats. As a promoter developer, we had foreclosed the loan. My lord, these are the original copies. On the last occasion, your lordship was pleased to direct me. I
do not have the copies.
Yes, I am giving. So you have, sir. For all these 5 loans.
So you paid on behalf of the buyers.
I paid because the buyers didn't want to buy the flats. So the buyers that they have given the understanding, I have paid back to them. And the other amounts the bank has given to me, I have paid back to the banks. After this, my lord, and at paragraph 23, my lord, I have pleaded regarding the outstanding amounts of each person, and these are the copies, my lord, that were given to the bank. After waiting for several months, we were not given the no outstanding certificate, nor the original documents. Rather, on the contrary, if your lordship kindly comes to page 34.
Yes.
When I take the indulgence to read the second paragraph, this is a relevant paragraph. At the outset, we vehemently deny all the allegations and contentions raised in the notice under reference. As you have asked for the original agreement for sale, along with no due certificate of the project, namely Sonarbhumi being holding number so and so, for 5 housing loan accounts, but in the aforesaid accounts, investigation is underway, and at any point of time, the concerned authority may ask for the original documents. Hence, the bank is not in a position to hand over the original documents. Now, my lord, the first question I ask to myself is, who is the authority? Who is investigating? I don't know. Nothing has been published. On an apprehension that whether that investigating authority, whose name has not been stated here, will ask for documents, for several years, my original documents have been blocked. When all the monies are paid, they have received everything, there is no due. If they try to call it as a fraud, then also there has to be a wrongful loss and a wrongful gain. When the money has been paid, when there is no wrongful loss or gain, if they claim, even they are suppressed, rather I must say, the investigating agency's name, they are not giving us the original documents.
Yes, Mr. Saha.
Well, things are not so simple, my lord, in the way my learned friend tried to portray, my lord. My lord, multiple frauds happened. More than 63 accounts are involved. What kind of fraud, my lord? Suppose the flat has been, an agreement for sale has been entered into with the developer and with X. Loan was obtained in the name of X from the bank. The flat was not sold to X. It was sold to Y or Z. And multiple time it was
all
sold.
This has to be recorded.
I'm coming one by one. So all these things happened. These are all on record. And for that reason, we have lodged our complaint before the CBI because more than 16 crore fraud is involved. My lord will be aware that there is a circular of the RBI. If the amount is more than 6 crore, the bank should report that before the CBI. My lord, what he is asking for? He is asking for the agreement for sale, the original agreement for sale. According to him, the loan has been foreclosed and there is no agreement subsisting between the customer or to whom the flat was intended to be sold. There is no agreement now. Now he is wanting the agreement back. But he may not have any requirement for that agreement. But
Well,
we,
the bank will
as a
decide
banker,
this.
because we have already lodged a complaint
While
before
the bank
CBI,
will decide this, whether I have the original documents with me
because
or
its
not.
purpose is over. Now it
The
is
bank will
asked, my
decide
lord. It is
with
the
some
original
stories.
document. Because this is the instrument by which this fraud has happened, my lord. Kindly appreciate, my lord. This is the document.
No, but if the
It is
loan
not a
is
title deed, my lord. It's not a title deed at all. It is only an agreement
So
for
no
sale.
outstanding certificate.
With the help of this document or with the aid of this document, this fraud happened. So these are the vital documents.
no, but if the loan has been repaid, then why will you hold on to the document?
But fraud has happened, my lord, because my lord, kindly see, we have the law, the complaint that we have lodged, my lord, may not be permitted to share this document because we have lodged a complaint and CBI is yet to draw up the FIR. Since CBI is not drawing up the FIR, we have also filed a writ petition before this honorable court.
But whether these accounts are involved, kindly, they are not giving us any copy. Though it should
No,
be
at
shared
the
with us
stage of,
also.
my lord, at the stage of
Because
recording
I have the right
FIR,
to exception.
it is well settled.
No FIR has been drawn up.
The doctrine of
Just now it has been stated, my
doctrine
lord.
of natural justice does not.
Just now it has been stated that no FIR has been drawn up by the SBI. It was only submitted by him.
My lord, kindly cease.
Whether these 5 accounts are there, I don't know, man.
You file your affidavit.
My lord.
because This requires a hearing. We'll see. लिखे नहीं?
Preamble 1, I appear for the state. Respondent number 6.
My lord, if my lord kindly recollects, you had specifically instructed that unless and until all the respondents are here, you won't listen the matter. So praying for like not today because on the ground of
All right, an accommodation is prayed for on behalf of the petitioner. Full stop.
Also, Lordship, one submission, the way we have been served, the GP office, is only the synopsis bit has been given. The main bit
write.
has not been given.
An adjournment is prayed for on behalf of the petitioner. Full stop. It is submitted on behalf of the state authorities that a complete copy of the writ petition has not been served upon the state respondents. Full stop. List this matter for further consideration on December 5, 2025. Copies of the writ petition may be served upon the state respondents. Complete copy of the writ petition may be served upon the state respondents in the meantime.
My lord, I was appearing on behalf of the Enforcement Directorate. My lord, I have a small request before your lordship.
Fridays, because it's specially assigned matters, I take it on Friday.
My lord, I have a small request before your lordship.
Yes.
I was appearing on behalf of Enforcement Directorate. My
Yes.
5th, I will not be here in town. Can it be on 12th?
12th December.
12th. My lord, deeply obliged.
Grateful.
12th. Yes.
Your 302, I am for the petitioner.
I am for the respondent.
If your lordship kindly takes up 302 and 303 together, both are applications.
303
Analogous.
What is the matter in this?
Lord, this is regarding a compensation of 1 lakh rupees as per the Prime Minister's Relief Fund on acid attack victims. Lord, I have made my representations. The acid attack was, if your lordship would kindly see, was on 26/8/2016. Thereafter, I have got some reliefs as per 257A of the CRPC, but I'm also entitled to get this Prime Minister's Relief Fund of 1 lakh rupees as per the NALSA scheme. The NALSA scheme, if not takes up, starts from page number 22.
Yes, who is appearing for the
Union of India.
Oh, State Legal Services Authority of served.
Yes, my lord. This is actually, Lord would kindly see.
Who is the State Legal Services Authority is to make payment or they have paid?
Look, this is to be disbursed by the Union of India since it's a Prime Minister's Relief Fund.
Where is your representation?
My lord, representation I have made on 9/7/2024. Page number 27. Their mother and son.
Page 27.
27 of WPA 3261 in case of Shrujit Kamal. I apologize, my lord. In case of Geeta Kamal. Geeta Kamal. 3259.
Page 27.
Yes, page 27 onwards.
Page 27 is something else. Page 27 is a scheme, part of a scheme, somewhere midway of the.
Not 37. I apologize.
37.
37.
37.
Annex P3 or P5.
Yes, but this is addressed to the State Legal Services Authority.
Yes, my lord, but the disbursement will be made from the Prime Minister's Relief Fund. So so it's also written in the NALSA scheme that if they receive any kind of representation, that they will be directing to the proper authorities who will be disbursing these 1 lakh rupees.
Who will be directing?
SLSA or DLSA, anyone who on receipt
Have
of
they
this.
done it or not? Have they directed?
No, my lord, no, my lord. They have not done it.
They have not forwarded it.
No, my lord.
Is there somebody appearing? Then I can
No.
direct them to forward it immediately so that can you serve them a notice and come back on the next day?
My lord, I can do that, but this is a statute as per the NALSA is 1 lakh rupees is a very normal
It will be
amount.
easier. Then we'll have a picture. I can direct in any case.
But if the Union of India is present, the payment can be directly made from their end also.
No, but if
No
there is a
instruction.
scheme to be followed, it has to be forwarded. Then in that case, many things have to be seen. I cannot blindly direct.
Lord, page number 30, if your lordship kindly says, victims of acid attacks are also entitled to additional compensation
no
of
question on
rupees.
your entitlement. The question is you have to follow the procedure. Where is your service?
Yes,
Milord would see just at the bottom of the page, it says that how it would be disbursed. Victims of acid attacks are also entitled to additional special finance assistance up to rupees 5 lakhs, which will include treatment expenses, such and such compensation paid by the respective state or union territories in terms of Central Victim Compensation Fund Guidelines 2016, number such and such. Page number 30. Victim of acid attacks are also entitled
30 of which one? First writ petition or second writ petition?
Milord, Geeta Kamal, the mother. Page number 30. Point number 3, just at the bottom of the page. Victim of acid attacks are also entitled to additional compensation of rupees 1 lakh under Prime Minister's National Relief Fund, wide memorandum dated such and such. This is separate to that of the SLSA and DLSA. Point number 2 states that how SLSA and DLSA should be disbursing on receipt of that, provided that in case of acid attack of amounting rupees more than 1 lakh shall be paid to the victim within 15 days of the matter being brought to notice of the DLSA. The order granting interim compensation shall be passed by DLSA within 7 days of the matter being brought to its notice, and the SLSA shall pay the compensation within 8 days of passing the order. The remaining guidelines that when that amount should be paid.
Yes, but to get it from Prime Minister's National Relief Fund,
yes,
some application has to be made somewhere.
Milord.
Where has that application to be made, and where have you made it?
I have made it to SLSA and DLSA, and they are to redirect it if they are not the particular authority to disburse that amount.
Where do I get that?
No, just
because you said you have received something.
Yes, I have received something.
So where do I get that you have to receive for receiving the other quantum? How will you get it?
Milord, the other quantum.
Because this is additional. This is additional.
This is additional.
This is exactly your case.
Yes, Milord. That is.
How do you get that? Show me.
Milord, this says that victims of acid attack are also entitled to additional compensation of 1 lakh.
So that is what you are asking for.
Yes, Milord.
So additional compensation in what manner?
Okay. Milord, there is one memo number 24013, Government of India, Ministry of Home Affairs.
That is written there only.
Yes, yes. So it says that additional compensation of 1 lakh to the victims of acid attack under PMNRF is addition to the compensation under the Central Government Victim Compensation Fund Scheme. Milord,
but you have to make some application somewhere. Without making an application, how will you get it? You make an application somewhere else and you expect compensation from somewhere else.
But Milord, that SLSA and DLSA is to redirect that.
To show me where that is. You are not showing the provision. You are only making that submission. You serve a notice on the SLSA and come because you are also not ready. You are not being able to show the provision also, and you don't want them to appear also. You serve them a notice and come back. That is what I said at the very beginning.
Milord, I will do that.
Then it would have been easier. Then all these 15 minutes would have not been wasted because you are not aware of it. You don't want them to be here. Read your brief, read the law, and don't try to take orders again without serving. That is uneasy always.
Milord.
It's always better to serve and take orders.
I understand.
94, 94.
Yes, you're supposed to file a supplementary.
Firstly, my lord, copy has been served upon them, my lord. They have also received the copy, my lord. Your lordship directed, my lord, the Calcutta Telephone District Cooperative Limited to be added as a party. I've added the party, my lord. Copy has been served upon them along with the writ petition. And my lord, only my lord, kindly, my lord, grants me, my lord, some leave, my lord, to file, my lord, the affidavit of service, my lord, that is being, my lord, made ready, my lord. Otherwise, my lord, they have, my lord, received.
Supplementary affidavit.
In respect of supplementary, my lord, I've taken particular instruction, my lord. This writ petition, my lord, the writ petitioner is the wife of the deceased employee. My lord, they are, my lord, she is unable, my lord, to get any documents with respect to the old loan. The loan was, my lord, paid off, my lord, at a very long point of time. My lord, let, my lord, this, my lord, if there is any dispute with regard to, my lord, the any amount of loan still pending, that, my lord, this respondent, my lord, the added respondent, my lord, should come and clarify, my lord.
Where will you have served them?
Serve them, my lord, affidavit of services, my lord, being ready, my lord. I'll just, my lord, file them, my lord, in course of the day, my lord.
I'm making it not today. Let us see if they appear on the next day. Serve another notice.
My lord, my lord, my lord, I'll do it.
Not today, my lord.
Then, my
All
lord,
right.
kindly, my lord,
It will not inure to his benefit to order record for him. It is নেই এখন চলুন হ্যাঁ চলুন দেরি করবেন না।
I am for the petitioner, my lord. In the last occasion, Lordship directed me to serve a notice upon the non-appearing respondents. I have duly served. 7 is a state respondent. She is not found in court number 2, room number 2. Now, my lord, the petitioner purchased a plot of land in the year 2023. He want to convert the land from Bai to Bastu, that is agriculture to homestead land. Now, the concerned collectors told the petitioner that the concerned plot is under the purview of ADDA, Asansol Durgapur Development Authority. Therefore, no objections required. The petitioner went there, verbally told that the particular plot of land is under development project system. So, permission not tenable. But just adjacent of this plot of land, another plot is got permission. Now, the petitioner made a representation stating all these facts and stating that
You are
plot of
appealing
land.
for the Asansol development.
My lord, I am appealing.
Why are you not considering their representation?
My lord, I will not get into the merits of the matter, lordship. Kindly directs, my lord, it will consider.
Consider it, whatever it is. Yes, you don't want to do. No, it's 2 o'clock.
My lord, present. Today, my lord, my learned friend request
Then not
me.
today. Not
Lordship, 2 o'clock OD or AD, Lordship, today.
80. From 3 p.m. OD, I think.
Today there is 3:30 resolution.
Oh, but list is published yesterday only. So. 5-6 দুটো not.
Lordship.
Thank you.
307, my lord, I am for the petitioner. This is my affidavit of service.
Who is appearing for the respondent?
Last 3 occasions, nobody appeared.
No, there is no order recorded. Last day may have been some resolution or something. Serve a notice on them, passing a direction. You are appearing? Yes. Yes.
In this matter, what happened, my lord, the petitioner made an application for passport on 18th October 2024. Thereafter, fixed a date of online appointment on 21st November 2024. The petitioner appeared on the date of appointment and produced all the relevant documents in support of her application. Thereafter, the petitioner found the status of his passport application. That is at page 38. Kindly come to page 38.
Yes.
Status. Police verification report is not clear and application is under review at regional passport office. Then the petitioner received a letter. That is at page 39 from the office of the regional passport office. May I read you? This is in reference to your passport application number so and so. Adverse police verification report has been received against your above mentioned file number, which is that, and the subject is involved in a criminal case found during local inquiry. In this connection, necessary documents are being searched. In view of the above, you are requested to visit 4 Brabham Road, Kolkata, Satlokha, with prior online inquiry appointment. The original of such documents need to be carried while visiting passport office. If the service is rendered, please ignore this letter or please treat this letter as cancelled. Then it's made with the office of the regional passport office. That is at page 40.
Yes.
And produce all relevant documents. Admitted fact, the petitioner, a criminal case is pending that is arose due to family dispute between the petitioner and his her in-laws family. But that is not a bar as per Passport Act. Mere pending of a criminal case is not a bar to grant passport.
Yes, Lordship, at the very present, may I hand over the copy of instruction to the Passport Authority? First of all, Lordship, while the petitioner has made the application, there has been a material suppression with respect of the pending criminal case against her. That is one suppression of fact, due to such suppression, section 10(3)(b) of the Passport Act enunciates that while making such application, if anything suppresses, if any material suppression happens, the Passport Authority is well within its ambit to cancel such application. One. Now, secondly, Lordship, despite that such suppression, while the local police station has visited and has done, which is relevant from page 6 of the report, Lordship, that is the police verification report, wherein the police has stated that while investigating, it has been found that a pending criminal case has already been there against the petitioner. In such cases, Lordship, what is to be done is that specification, which is Lordship will able to can you peruse it from page number 1, Lordship. The fourth paragraph, Lordship. As per the claim of the petitioner, it appears that she might have visited the office on so and so date with the objection letter to inquire about a passport application, and she might have been verbally instructed to submit the following documents. Now, in such cases, there are 2 requirements, Lordship. One, order from the trial court permitting her to depart from India. That is one. And this order has to be in consonance with the GSR 570E, Lordship. This is the notification, Lordship. Second page of the notification, Lordship, Gazette notification, it stipulates. May I read it, Lordship? In exercise of the powers conferred under Clause A of the Section 22 of the Passports Act, and in suppression of the notification of the Government of India and Ministry of External Affairs, GSR so and so dated, the central government being of the opinion that it is necessary in the public interest to do so, hereby exempts Indian citizens of India against whom proceedings in respect of the offences alleged to have been committed by them are pending before the criminal court in India, and who produces orders from the court concerned permitting them to depart from India. So the first part of my submission is that the order from the trial court, which has to be, which are required to be there, that has to be in consonance with the 570E. One. And second requirement is that an undertaking as prescribed under the provisions of the GSR 570E, Lordship. If these two things are in place, then even in despite of in the criminal cases pending,
When the petitioner made, nothing was disclosed, and till today, no order has been communicated to that effect. That these documents are required from you.
Now you have got this. Now
After
in
filing
fact,
this petition, after
the
filing this petition,
instruction clearly states by the authority
is there a
that
statement?
when she visited the office on 24th of January 2025, it was explained to her that what all requires to be done. These two requirements, as per as
very well, you inform them in writing about
Yes,
this,
I have
so that
stated
they
in
can
my
take
paragraph,
steps.
paragraph 17 of my writ petition.
Legally.
I was being I'm deeply grateful.
I have not used the word dismissed, but
If it is informed, written, then petitioner could take steps.
I beg to appeal for the petition, Lordship. Can you remember on the last occasion, it was pointed out that there were certain defects in the arrest of petitioners, my lord, the constitutional attorney, my lord. We have already taken steps, and application is being filed only today itself, Can 1 of 2025.
and agreement is prayed for on behalf of the petitioner.
For the bank conduct.
An agreement is prayed for on behalf of the petitioner. This matters for further consideration on December 5.
Along with the application.
Yes, yes.
Lordship, in this matter, I am appearing on behalf of the petitioner, Lordship.
Lord, I am for the state.
Petitioner, where is the petitioner?
He is supposed to be not appearing on online, my lord, virtually.
Lordship, I am appearing on behalf of the petitioner, Lordship.
Appearing for the petitioner?
Yes, Lordship.
Yes, what is the matter?
Lordship, no, it is the matter. Okay, the petitioner is a lawful inherited property of her husband, and she is possessing that property since 1996. What happened to that lordship? During her peaceful possession, her adjacent property, which was previously owned by one Miss Sheila Chakraborty, was sold to respondent number 5, Mr. Saurabh Mandal. Since acquiring the property, the respondent number 5 has indulged in unauthorized construction and illegal encroachment upon the common areas, causing severe hardship and obstruction to the petitioner peaceful use of property, and causes essential resources including water, electricity by blocking shared spaces and denying her rights. Lordship, what's happened thereafter? On 18th of January 2025, the petitioner was highly frightened and deeply agonized by the such scheme of the respondent number 5, who forcefully, illegally possessed the petitioner property and deliberately assaulted the petitioner by using filthy and abusive languages and threatened the petitioner with dire consequences. On that note, the petitioner lodged a complaint to the respondent number 4 for taking action against the respondent number 5. But no action was taken by the respondent number 4, the police authority, till date. Thereafter, again on 25th of January 2025, the respondent number 5 locked the petitioner out of her residence and obstructing access to the essential facilities such as washroom and all. Thereafter also petitioner lodged a complaint to the respondent number 4, but they have not taken any steps against the respondent number 5. On the last occasion, your lordship was directed the state to provide a report, but
My lord, this is my report. Case has already been started, my lord. Under section 126, 135, 3. But, my lord, so far the matter is purely civil in nature, my lord. Police has.
No, police has already taken steps.
And, my lord, not only that, my lord, proper party has not been added. He is saying that, my lord, if your lordship kindly see the prayer, he is asking for, my lord, his water connection and electricity connection. My lord, it is not within the periphery of the police, my lord.
Water connection, electricity connection you had in your name or you don't have in your name?
I have in my name, lordship.
Then if the private respondent is interfering with your water and electricity connection, writ court will not be able to help you. You have to file
Lordship, I have come before this writ court because police was not taking any steps.
Police inaction, yes, definitely. Writ court will intervene and they say that they have initiated a case. So that case is taken to the logical conclusion. That's all that I can say.
Lordship.
Deeply obliged.
The petitioner complains of inaction on the part of the respondent police authorities in not taking steps, in taking steps against the respondent number 8.
Respondent number 5, Lordship.
Sorry, respondent number 5.
Yes, Lordship. Private respondent.
My lord, private
Number
respondent.
5. Respondent number 5. Who has allegedly threatened the petitioner with dire consequences and criminally intimidated her. Full stop. Paragraph. Learned advocate appearing for the respondent police authorities hands up to court a copy of the instructions forwarded to him by the ICI
IC
Uttarpara police station, wherefrom it appears that on the basis of the complaint lodged by the writ petitioner,
prosecution under section 126, 125(3).
An inquiry had been conducted and after completion of the same, prosecution under section 126/135 within bracket 3 BNSS has been initiated against the respondent number 5 and his wife, being Kanaipur B/H NCR number 47/2025 dated January 25, 2025. Full stop. Having noticed that a prosecution has been initiated under section 126/135(3) of the BNSS against the respondent number 5 on the basis of the petitioner's complaint, no further order can be passed on this writ petition. Full stop. WPA 3425 of 2025 is disposed of by observing that the respondent police authorities shall take the case initiated to its logical legal conclusion in accordance with law. Full stop. That's it. Dispose of the body.
Oblige, Your Lordship.
Court is instructions taken on record.
Deeply obliged.
Deeply oblige, Your Lordship.
This is my petition. Lord, the drawing Lordship's attention only the prayer B.
Refund of earnest money.
Yes. My lord, what's happened, my lord? The petitioner participated in the e-auction of 8 ferry yachts, and the amount has been deposited. Now, I draw Lordship's attention, page 84. Page 84, annexer P3. Only a message has been received. You are informed that your EMD payment has been rejected due to false documents submitted. Before entering bid tender, before holding the tender, my document has been rejected. That is also the before holding the tender. As per the scheme, as per the tender process, my documents has been rejected. Though it is the provision, the documents will be invited after the tender for allotment of agreement. That has not been done. I am not disputing about that. We are paid for return of the amount. This is
the has been forfeited or what?
No, this is not the clause of forfeited since I am not participating in the tender process. Since I am not participating in tender process.
Milord, this BDO has given me the instruction. May I respectfully, Milord, hand over a copy of this?
Yes.
I am not
And
saying.
he is the executive officer of the Panchayat Shomite, I believe. Milord, he sees that, kindly see the first paragraph,
Give me the copy.
that there was an e-auction and petitioner duly participated. That is the first paragraph all about. Second paragraph says on 25th September 2020 auction was held. Third paragraph kindly was what was the fact. The sentence starts with the what the fact is that document containing the cargo vessel license showing validity with effect from 22nd August 2024 to 21st August 2025 submitted by the petitioner had been verified from the office of the Shyama Prasad Mukherjee Port Kolkata office, and the said document had been identified false by the license issuing authority with a mail dated 21st September 2024 against our letter under memo number so dated 21st September 2024. Both the copies of mail are annexed here, marked as P10 and so and so. Next paragraph, the action has been taken accordingly. Petitioner found to have forged and misled the auction process, hence no respite allowed. Document false affirmed and explained in the above para. Petitioner himself committed guilt and claiming so and so, no restriction imposed. Then, Milord, the third paragraph from bottom, the sentence starts with the fact that the petitioner deposited earnest money in respect of all the ferry guards under the auction. Petitioner provided forged document, hence disqualified. Notice for demand, justice received, action taken. Copy of action taken is herewith. Explanation sought, nowhere mentioned that EMD will not be refunded. So I find that,
Willing to refund EMD that.
yes, from the representations which he had given, so that may be sent before the jurisdictional authority to consider his prayer for a refund. That is what the report says, that no such prayer to that effect has been ever made for.
No, they say that they had written a letter on 14th of January 2025.
Lordship, may I respectfully invite your Lordship, my Lord, to P13 by 1 and P13 by 2 and P13 by 3 of the bunch of document, Miller. I have respectfully handed over to your Lordship. P13 will appear from page 31 of the Miller bunch of document, Miller.
Yes.
No, I have not yet handed over a copy to my learned friend, Miller. The copy I am relying upon.
The copy
No, certainly, Lordship. So,
Lord, then I have to, of course.
I am not on combative mood. So you may come back tomorrow, kindly retain it in the position, I mean Monday, Lordship.
Very.
But my respectful submission to that, my Lord, my respectful whatever stated, page 84, kindly appreciate. This is their document by message. I cannot participate in the auction proceedings.
Very well, but they say that you had supplied forged documents.
That is for document. That will be time of verification when I participate in the tender process. That is their pen. I don't lose attention page 29.
Then should I invite affidavits then in that case?
No, that is another thing. What submission?
That will be better then everything will be flashed
Then your
out.
lordships, I come back with the my lord, the gone through this document. I come back tomorrow.
These documents, like without an affidavit, what value will they have?
That then your lordships giving the.
It is better.
Yes, or short direction we given.
Yes. They'll file a report in the form. Petitioner.
This writ petition has been called on several times, Manoj. This is for a grant of a credit facility. A credit facility was not given to the writ petitioner, hence my
None appears for the petitioner. Full stop. No accommodation has been prayed for. List.
I am for the led by Mr. Ghosh. I am filing my evidence service. Now, the present petitioner is a transport operator. She engaged herself to carry school children in the colliery belt, more particularly Ramnagar colliery. It is governed by Steel Authority of India Limited in short sale. In 2023, a tender was floated. Kindly straightway come to page 48 of my petition.
Yes.
Your Lordship, kindly see the subject: engagement of school buses and van for school-going children of Ramnagar colliery, Shell Collieries Division. This was the subject. On this issue, tender was floated. Kindly come to my lord, page 52. 52. Scope of work. Now, there are 3 columns are there, A, B, and C. So, for column number B is concerned, I have opted. Route number 2, one 15-seater school van shall collect students from various locations points at Ramnagar colliery and transport them to Borakar Jarau Devi School, to Begunia High School, to Kulti Girls and Kulti Boys School and back. That is up and down 20 km via Borakar, starting from Ramnagar dispensary. For this work, my lord, I had opted. Then, my lord, kindly come to next page, page 54.
Yes.
But there was a condition, my lord, in that tender paper, column number 8. It was mentioned that driver / khalasi shall check the identity card. I am emphasizing this order. Identity card and letter of permission of each student boarding the bus and shall allow only those having proper document to board and shall not under any situation allow student to board who does not possess relevant document. This was the condition. But thereafter, my lord, since I, my lord, successfully submitted a tender paper, I was selected. Page 84 is the work order. After awarding work order, I made a prayer before the authority. Please supply me the names of students and, my lord, their identity cards. In absence of that, my lord, there are so many local students of that area are boarding that transport, that vehicle, and it may take at any point in time accident. It may cause danger to the students. Very innocuous prayer. I sent several mails, advocates letter. Please supply me the names of students and identity cards. This is my prayer. That was not given.
My lord, first they have to comply with all the terms and conditions of the notice inviting tender. For example, a formal contract, there are criteria, the bus, the vehicle, it has to be clearly displayed. Then if the vehicle is not owned by the contractor, then a lease agreement, all these formalities have to be complied with. They have not done that. Any of those, and we have sent letters.
No, but you have issued a work order.
Yes, and they did not start the work. The work order is of 18 November 2023. This writ petition was filed on 12 February 2025. Work has been started as per my instructions on 18th March 2025. As on date this writ petition was filed, they did not even start the work. And it will be clear from the correspondence on record.
No, but they are unable to start the work because they don't have the whereabouts.
The correspondence will show that the petitioner suffered a leg injury. She fractured her leg. That's why she could not start the work, and additionally she kept this point that please supply me a list of students.
But this is also a valid point because they are for the purposes of transporting the school children only. And if they don't know who are the children and the children who are boarding are different from the one for whose purpose the tender was given, then that frustrates the purpose of the tender. So why should not be, why
Well,
should they
first
not be
thing
informed
is,
about it?
my instructions are this list is provided once they comply with all the formalities. Since they did not start the work for so long, it was not clear whether at all they will work or not. But 2 years, the work order periods was for 530 days. They have started work almost after 1.5 years.
I shall show one more I shall show only one document. Kindly come to page 113. 113.
Yes.
Kindly see, this was the reply given by them pursuant to my application under the provision of Right to Information Act. Kindly see, my lord, the reply number 2. As per NIT, there is no stipulation clause to provide definite names of students and their father's name. This is their stand.
Yes, sir.
Yes, my lord, this point I am also taking that there
This
is
point you did not take. You took a different point. They
Yes.
say that you are not providing it at all. You said list is ready. We did not provide because they had not done something which was doable at their end.
Fine, my
But
lord.
this says absolutely different thing.
Yes, my lord. This is with regard to the maintainability of the writ petition. There is no contractual right or constitutionally protected right that the petitioner can claim that it has been violated. This is the technical point on the maintainability of the petition. On merits, my lord, I submit what I submitted earlier. And secondly, if my lord kindly comes to page 92, we had informed them these are the particular clauses you have not complied with. You have to comply with them first. Page 92 is our letter dated 15th April 2024. If I may place, my lord. Yes. You had been requested via our earlier letter number such and such dated 28 March 2024 to comply with the following clauses stipulated in the special terms and conditions of the instant NIT. Then the clause numbers and the provisions are given. None of these have been complied with. Next, after the column, but till date you did not comply.
Yes, what is your answer to this?
Well, my instruction, everything has been complied. Still, my lord, I am submitting.
Over the page
But
shows
that
93.
written instruction at the present, my lord,
This is the reply. I want justice.
I do not have. But my lord, if anything remains non-compliant, I shall comply within 7 days. Let them supply the list. Within
You have
7
to
days, I shall
with
comply.
This. This was given to you more than 1 year back. Why have you not complied with this? They have written, it seems you are not interested because time and again you are once again requested, you still not complied with. Then, if you yourself are at fault,
Well, my instruction, everything has been complied. Since they are, my
your
lord,
instruction will not do. Your writ petition is there before me. It should be
that
there.
was
in
not
the
the
writ
issue,
petition.
my lord. I did not highlight all those things in my writ petition. Now they are saying all those things. This was not complied with.
Has this been complied with? Now, since an issue has been raised, you have to answer that. It should have been your case that you have complied with all your formalities. Despite that, they are not giving it. That is the way you draft it. Why you should not? Why should you not show whether this compliance has? Because this is a point taken now.
In that event, my lord, kindly keep it on next Friday. I shall come back with the instruction whether this part has been complied with or not.
An adjournment is prayed for on behalf of the petitioner. This
Fine, get me.
28th is okay with you? Want a different date?
It's all right. Good.
Lordship, I beg to appear on behalf of the petitioner and I am led by Mr. Karthik Bhattacharya in this matter. But he has some suffering from some illness, so that's why I'm just praying for not to the Lordship.
My lord,
313 and 314.
I am for the respondent number 4. Then, my lord, direction for affidavit is granted by.
What is the matter?
The matter is about the petitioners of the father and mother, and the respondent number 4 is son.
Yes,
And for
Lordship.
the son. This is regarding some
Fixed
deposits.
certificate issuance of
Very
duplicate.
well. He's praying for time.
His lordship and the affidavit of
Affidavit, you keep it with this.
lordship.
An adjournment is prayed for on behalf.
My lord, I'm praying for not today on behalf of Mr. Mukarram Hassan, petitioner advocate. Only not today.
ওই same order করে দিন।
28 will be.
12 December.
Oh,
Next.
I'm grateful.
My lord, 316 I think petitioner will not turn up because the grievance stands redressed. May I respectfully invite your lordship to the prayer clause, kindly sees what does he want, and that has been done by the authority, I find. Written instruction is there, my lord. May I respectfully, my lord, invite your lordship to page 6 of the petition, my lord. The prayer clause starts. Page 6. Kindly sees the aim is mandamus to cancel and set aside the e-tender process by issuing fresh tender notice. The NIT under challenge, lordship will get, my lord, at page, my lord, 9. This is the NIT under challenge. NEET number 1015 dated 25th September 2024. Now, my lord, may I respectfully hand over a copy of the instruction, my lord, given by the tender inviting authority.
দেখুন ওখানে দিচ্ছে কাগজ দিচ্ছে না।
Tender inviting authority is page 15, that is district program officer, and this instruction issuing authority is also the same. Kindly see what does he say, my lord. Bring to your notice that the tender process for engagement of carrying cum storing agent in respect of Kotulpur ICDS project invited VDA NIT number 101 fellowship.
Putting it under for dismissal on Monday.
Expedition is otherwise not entertained, should not be entertained as the brother said, because it has been quite challenging the order margin of system.
লিখে নিন ওই সেম অর্ডার যে none appears for the petitioner
My lord, in 18 to, I am appearing for the petitioner. In
Lordship,
terms of your lordships,
I'm appearing
if
to respondent one and
service position. My lord, on the last occasion, as it fell from your lordship, there is a question whether the writ petition lies against the Axis Bank, that is a private bank. My lord, here my main prayer in the writ petition, I'll go into that question, whether it is maintainable or not. I have come up with a judgment. My lord, prior to that, my lord, yes, judgment of the copy. Of 1989. Honorary Mukta Sadhguru.
Oh, that I know.
Yes,
Everybody knows.
But that apart, keeping it aside, but my main prayer is against the respondent number 1 and 2. That is RBI.
Yes. What happened?
But the Reserve Bank of India is the prime banking institution, undoubtedly, my lord. It, my lord, as authority, issues necessary order on the.
What is the
yes, facts of the case. Well, there is small
not
facts
fact
of the case.
What is the act that you are challenging on the part?
But I am stating before the small facts, my lord, within by 4 lines. I am maintaining an account with the Axis Bank. My lord, my fixed deposit account prematurely encased and credited to my account, and thereafter debited to other and transferred to other accounts beyond my knowledge. This encashment, premature encashment, also without any authority, without any request from my side. If they deny, let them produce any document in support of that, or denying that.
No, how is
Then, my lord, thereafter, two loan has been credited to my account without my request, without execution, any loan agreement, nothing of the sort, nothing. And those amounts were also debited and transferred to other accounts. Then I made complaint. Nothing was done. Then they said that I should make complaint to the Cyber Crime Commissioner. I made complaint. Challenging the police in action, I filed an inspection. My lord, in that writ petition was disposed of by the order, which I have annexed at page 8 of my supplementary affidavit. If your lordship kindly takes page 8 of my supplementary affidavit. I'll place it before your lordship. Very interesting. Petition is agreed by the fact that the investigation in connection with the Cybercrime Police Station, Chandanagar Police Station, being case number so and so, is not progressing. Petition is agreed by the fact that the bank officers have not been interrogated or implicated in connection with the instant case. State has submitted report. Report reflects that so far as the nature of the transactions are concerned, police authorities have been tracking the money trail and has been able to locate 2 of the accused parties involved in the alleged offence. Search in respect to the other are still on.
Yes,
so, my lord, ultimately, the investigation is still going on. It's still going on. My lord, my respectful submission before lordship involved that whether and when an investigation is pending by the appropriate authority in respect of the correctness or the validity, or whether I have given any instruction to issue loan, those are the subject for the investigation. When this investigation is on, can the bank proceed to issue notice, legal notice, for recovery of the amount? When the investigation is still on, as per this order, can the bank authority proceed with the recovery?
What will they do in that? What will the Reserve Bank of India do in that?
Reserve Bank of India, I have made a representation.
Reserve Bank of India is not supposed to look over this. If you have a grievance,
in my humble submission, yes, my lord. Why I am telling you, lordship, the Reserve Bank of India, when there is an illegal loan transaction, certainly Reserve Bank of India can take steps.
Whether it is illegal loan transaction or not is not clear as of now. Merely because investigation is going on, you cannot label a transaction as illegal beforehand. Right?
But
If you
at
want,
the same time,
sir,
may
you
I?
allow the court to complete, then you
I'm
speak,
sorry.
or I will keep quiet. You make submissions.
Your lordship, the submission that I wanted to make has already fallen from your mouth, your lordship.
I'm sorry, my lordship.
No, you continue.
No, my lordship, can't.
Continue, please continue.
Well, the Reserve Bank of India is the authority
For what? Not to oversee loan transaction. It is not its business. Then Reserve Bank of India will have to be closed. If it starts monitoring every transaction of every bank, then it will have no business to do.
At least, my lord, when
if somebody has committed illegality, you have authorities before whom you want the bank to stop recovery. Then in that case, there are authorities whom you can approach that this is an illegal notice which has been issued by the bank. I want an order of injunction. The bank should not do it because this is the process. By this way, by way of an oblique purpose, you cannot.
No,
repetition
I am saying.
Anyways,
that
today I don't think you will be able to complete. It's 3 p.m. I have original side matters today.
নেক্সট শুক্রবার রাখবেন না, দয়া করে রাখবেন পরের শুক্রবার আপনি আসবেন না।
Next Friday.
My lord,
please be here next.
One indulgence, may I pray with us? Next Friday, I have personal difficulty.
One matter already.
Friday.
Grateful.
Supplementary affidavit filed on behalf of the petitioner taken on record. Copy thereof. Please have a copy.
Yes.
Only
Mr. Chaudhary will not be able to finish, isn't it?
Yes.
Because 3 p.m. we have original
Yes,
side
yes, my
matters.
lord, I
So
know.
no use starting.
Yes, yes. Very well, my lord.
We have original side. They'll get only half an hour. Don't take their time. Petitioner is not here. All right, not today.
Lordship, kindly keep it on next Monday or Tuesday.
It will appear on next Friday. 28th.
Not 295 Passover matter. I could not be able to mention because the other side is not here.
Yes. It was called on. Passover was called on. Nobody was there.
Nobody was there.
Nobody was there.
Yes. Lordship to be taken up.
Yes.
Then can I give another notice? Yes.
Yes, you can take.
I don't want to because I have given this therefore we have to fight. Our only question was that whether the language without that is the only
pass an order for dismissal on Monday.
First point that I have challenged the cancellation of my work order. Therefore, even if I want with regard to the With regard to the first point, that this is total arbitrary exercise of power. It is then I will not get it. Because my defense is to file a suit for damages to police.
So far as blacklisting part is concerned, that only that part.
Lordship, in item 319, petitioner is not appearing for the several times, my lord. Kindly keep it on dismissal.
No. There is an order, he had appeared. Don't say that. There is an order recording.
Yes, my
Detailed
lord.
order. You had not appeared.
Grateful, my lord.
Lordship, item number 326, Monday and Tuesday, I have some difficulty, Lordship.
Friday. These are assigned matters. Assigned matters.
My lord's kind permission, my lord. This is an mentioning upon notice for inclusion in the list original side matters. My lord, the agencies, my lord, the demand has been raised, my lord, along with an accrued interest, despite pendency of the writ petition, my lord. So that matter, the matter needs to be heard.
It's not there in the list.
No, my lord, it's not there in the list.
What happened? Chalo. Mentioning the other side. What application under item number 1?
I am on behalf of the petitioner, Shivnath Saha Chaudhary. My lord, we are pleased to note that in the last year order dated 3rd November 2025, you directed the Revenue Department to submit their affidavit in opposition. But till now, date, we have not received that affidavit in opposition. I put a reply also. So we'll be pleased that if you kindly fix a date.
But there is a delay on our part. We will not affirm the affidavit, 7 days delay. But he occurred because the petitioner did not make the proper respondent assessing officer party. He has made party the PCIT, and the respondent number 2 income tax verification unit is also not a good party. Thereafter, taking the approval from the PCIT, I have some delay. This is my kindly accept that I'm certain copy.
Affidavit in opposition filed on behalf of the respondent revenue authority is taken on record. Full stop. Copy thereof has already been served upon the learned advocate appearing for the petitioner. Full stop. You want to file reply to this?
Yeah.
For hearing.
My lord, I appear on behalf of the petitioner, my lord. On earlier occasion, your lordship was pleased to direct the supplementary affidavit to be filed, and that was filed on that day, and a copy thereof has been handed over to the learned friend appearing on the other side, my lord. They sought for time for consideration of the supplementary affidavit.
Yes.
My lord, it's a short point is involved, my lord. Partly they have agreed to my objections.
Oh yes, I remember that stamp duty thing.
Yes, stamp duty
Which
only.
Ayan Banerjee was supposed
Yes,
to
Ayan Banerjee is appearing, my lord.
Where is he?
My lord,
He was there in the morning.
lordship, I noticed, but I do not know.
I'm passing it over, Ken, if you can get him come back. Or should I make it not?
No, only half an hour is. Well, let it be.
Not.
I'll intimate him in the meantime.
Not today.
Not today.
I am for respondent.
Lordship, I am appearing in item 3, 4, 5, and 6 for the petitioner. Lordship, this is a case where the sanction order is passed for launching prosecution against me for delayed deposit of TDS.
Please start again, madam. I couldn't get you.
Lordship, this is a case where the sanction order is passed against me for the offense that I have deposited TDS with delay, Lordship. But Lordship, in this case, the entire TDS along with interest was deposited much prior to the issuance of any show cause notice, Lordship. And this issue was dealt by with several high courts, and even the Supreme Court had dismissed the SLP of Jharkhand High Court, whereby once the TDS is deposited prior to the issue of show cause notice, the prosecution need not be launched, Your Lordship. So this judgments and everything was cited before the commissioner. However, the sanctioning authority did not consider any of this and passed the sanction order without any application of mine, Your Lordship. My case is that. So, Lordship, may I take you to the show cause notice?
Yes.
Lordship, kindly explain. The show cause notice is at page 34, Lordship.
Yes, 34.
Yes, Lordship. So, Lordship, the commissioner has issued the show cause notice. And you see yes, para 5, Lordship. Further, besides charging interest under 2011A of the Act on delayed deduction or delayed payment, the assessee deemed to be an assessee in default is also liable for prosecution under Section 276B of the Act, which deals with the consequences for failure to pay tax to the credit of the central government. Under Chapter 12D, the provisions of Section 276B of the Act are reproduced below. Failure to pay tax to the credit of the central government. 276B, if a person fails to pay to the credit of the central government the tax deducted at source by him as required by or under the provisions of Chapter 17B, or he shall be punishable with rigorous imprisonment for a term. Lordship, the 276B has been invoked. And Lordship has asked for the details why the TDS amount on page number 36, Your Lordship. They asked that why the default TDS amounting to 13.4 crores were made during the financial year, but the same were deposited into central government account on or after the due date. If not, please furnish the evidence that how this information is wrong, whether the similar default has ever occurred in any earlier or later years, name and designation of the person responsible for making payment, and name of all the directors. Lordship, we have replied this to the show cause notice, which is contained at page number 41. Lordship, page number 41, my reply is there. Yes, Lordship, we have cited the circular dated 18/10/2016, whereby if the assessee has deposited the entire amount of TDS along with interest before receipt of notice from AO, then the said fact should be considered while processing the case for prosecution. This was by the CVDT circular, Lordship. This was cited before them. Lordship, we have reproduced the relevant paragraph also. That Section 278AA of the Act provides that for the purpose of Section 276B, no person shall be punishable for any failure referred to in the said provision if he proves that there was a reasonable cause for such failure. The fact that the deductor has remitted the tax before filing of TDS statement and interest before receipt of notice from the AO for prosecution may be taken among other submission of the defaulter while considering his case for prosecution.
Yes.
Lordship, the judgment of Dev Multicom, the Jharkhand High Court judgment against which the SLP is dismissed was also cited, and other several judgments were cited of Patna High Court and other Odisha High Court judgments were cited. Also, the reasons were given that why the delays occurred, that primarily that year was a COVID year, financial year 1920. The last quarter of the year was severely affected by COVID. Also, there was some liquidity issues faced by the company. There was some delay had occurred. Lordship, one correction also was cited that the delay is not with respect to 13.4 crores. The delay is only with respect to 11.17 crores because 2.31 crore has been deposited well within time. So there was that error in the show cause notice, which was also pointed out, Your Lordship.
What was the reply?
So-
And how was this so-called reply dealt with?
Your Lordship, the order was passed. Your Lordship, the order is contained at. Yes, Lordship. Yes, so Lordship, page 79, the order is there. Your Lordship, the only thing was considered while sanctioning is that on perusal of the balance sheet of the company, the sanctioning authority did not find that there is any liquidity issues or the reason that there was enough balance. But none of the circulars were considered that if it has been paid before interest, before issuance of show cause notice, then why the prosecution should be launched. That thing was not considered. The circulars were not considered. Various other reasons were given. None of those reasons were considered. Only the balance sheet was considered. The analysis of the balance sheet was done. Lordship, at page number sanction order 81, at 81 para 5. The submission of the assessee has been considered. However, the explanation of the deductor company is not found to be acceptable for the following reasons.
Yes, sir. Why was that not considered? Because if there is a circular which says that
Yes,
it may be considered.
The sanction order passed on the basis of the judgment of the Supreme Court of 290 IPR. But in that case, the Supreme Court was pleased to hold that prosecution lies in tax deducted at source is not paid into the government account within the stipulated period. In view of the above,
Where are you reading?
paragraph 6, Lordship,
Paragraph
6.
of
And also, though I do not bring that judgment, also another judgment is also 443 ITR. To some extent, is my favor.
which paragraph, sir?
My lord,
Which paragraph?
my lord. Paragraph 42. 42, Lordship, first.
44.
Lordship, kindly say 42 first. In view of the aforesaid discussion, the sanction to prosecute granted by the second respondent cannot be held illegal or unlawful, nor the complaint can be held bad in law. The next contention of that since TDS had already been deposited to the account of the central government, there was no default and no prosecution can be ordered, cannot be accepted. Mr. Ranjit Kumar invited our attention of the decisions of the High Court of Calcutta in 193 ITR 300 interpreting the provisions of section 276B. The single judge of the High Court observed that there is no provision in the Income Tax Act imposing treatment that for delay in deduction or non-payment tax. Under section 276B, delay in payment of income tax is not an offence. Accordingly, the land judge such a provision is subject to penalty under section 201 of the Act. We are unable to agree with the above view of the Calcutta High Court. Once the statute requires to pay tax and stipulates period within which such payment is to be made, the payment must be made within that period. If the payment is not made within that period, there is default and an appropriate action can be taken under the Act. Interpretation canvassed by the Right Counsel to make the provision relating to prosecution nugatory.
No, but this circular is subsequent to the judgment of the Honorable Supreme Court.
Yes.
This circular is of 2016.
Lordship, I place reliance on the judgment of Bombay High Court, which after considering the judgment which has been just cited of the Madhu Milan, has considered the effect of the recent circulars and has held that now that
Also,
judgment of
another
Supreme
judgment of
Court.
the Supreme Court, my lord. Though, my lord, I am sorry, my lord, I could not bring that judgment, my lord. 443 ITR, 444, 43 ITR 239. But if it's occasion next year, I will show that judgment.
What is there in this circular?
My lord.
Paragraph 2,
Two.
I.
Paragraph?
Two, my lord.
You know, paragraph 2, I, offenses under section
270. But prosecution is a criminal proceeding. Therefore, based upon evidence gathered, offense and crime as defined in the relevant provisions of the Act, the offense has
I'm
to be
somehow
proved.
not getting it. Which place are you reading?
My lord. First page, paragraph 2, my lord. Yes.
Below paragraph. I,
Yes.
another offenses under section.
Failure, yes.
I. Double I.
No,
I, single I.
Single I, yes.
Cases where non-payment of tax deducted at source is to be so and so, and the delay in deposit is less than 60 days from the due date, shall not be proceed for prosecution in normal circumstances. In case of exceptional case, like habitual defaulter based on particular fact and circumstances of each case, prosecution may be initiated only with the previous
No, but
administrative
2016 circular has not been superseded by this.
No, Lord, that is no
That
super. No,
circular
yes,
remains.
yes. So, Lord, my respectful submission, Lord.
Why is this circular being placed? What is the relevance of it? That is not the submission also. The submission is whenever a payment is made prior to the issuance of show cause notice, then that should be considered at the time of issuing of sanction. Where is that consideration in this order? No.
But based, Lord, Lordship,
Not
Lord,
that. It says that the fact that deductor has remitted tax before filing TDS and interest before receipt of notice for prosecution may be taken amongst other submission of the defaulter. Now, very well. So, may be taken does not mean will not be taken.
Yes.
So, may be taken means it should have been considered somewhere.
Yes,
there is no reflection at all in the order.
It's correct, Lord.
Why? That is the question. Why has not
But
been considered? What
only-
would have happened if
but-
that had been considered?
Lordship, kindly give the short filing date of affidavit, Lord, and then I will give the reply. The short directions for filing the affidavit. Yes, it is true, my lord. Sanction of that, there is no discussions about the circular. I am agree with your lordships.
Affidavits at this stage, they are already enjoying stay. Yes, where is the Bombay judgment that you were referring to? Show me.
Yes, Lordship. Lordship, kindly see the Bombay High Court judgment. Lordship, kindly see from para 28 onwards, Your Lordship, where the judgment of Supreme Court was distinguished by Bombay High Court. Para 28, Lordship. There can be no second view in light of the ratio laid down by the Supreme Court in case of Madhu Milan syntax. At the relevant time, however, Mr. Jain has placed into service two decisions of the High Court, Jharkhand High Court, Your Lordship, which I am also relying on the Jharkhand High Court of Dev Prabha Construction. Your Lordship, the page number para 29, Jharkhand High Court judgment is reproduced. Kindly see Lordship, para 17 of that judgment, which is at page 24. Lordship, at para 17 of that judgment, it is an admitted fact that the TDS amount in all these cases were deposited with interest, and the chart with respect to the same is also annexed with the counter affidavit of department, wherein the date of deduction and date of depositing of the said amount has been mentioned. However, some delay occurred in depositing the TDS. Apart from one or two cases, the deducted amount is not more than 50,000. While passing the sanction order under Section 279, the sanctioning authority has not considered the CBDT instruction dated 28/5/1980 issued in this regard by CBDT. The CBDT guidelines was considered by the Patna High Court in the case of Sonali Autos, and after considering the guidelines, the court has interfered with the matter and quashed the entire criminal proceedings. In CBDT instructions, it is mentioned that the prosecution under Section 276B of the Act shall not normally be proposed when the amount involved or the period of default is not substantial and the amount in default has been deposited in the meantime to the credit of the government. No such consideration will apply to the levy of interest under 2011A of the Act. This is quoted in the case of Sonali Autos. Moreover, after receiving the deducted amount with interest, the prosecution has been launched against the petitioner, which is not in accordance with law. If the petitioner failed to deposit the amount in question within the stipulated time, that is by 7th of the subsequent month, it was required to launch the prosecution immediately, which has not been done in the case in hand. Section 278AA of the Act clearly states that no person for any failure referred to under 276B of the Act shall be punished under the said provisions if he proves that there was reasonable cause for such failure. The judgment relied by Ms. Amrita Sinha, that is the judgment of Madhu Milan, the CBDT guidelines were not considered. On this ground, these cases are distinguishable.
By what period?
Lordship,
By what period did you overshoot the time here?
Lordship, kindly see my reply. I have given the chart. Lordship. I'll just show you the reference. At page 43, Your Lordship.
Page 43.
In page 43 of my reply, I have given this breakup.
Yes.
Your Lordship, in para 6 of B, I have given the breakup of TDS of 8 crore 77 lakhs, the delay in depositing that. 1 month, 2 month, 3 month, 4 month. Your Lordship, the 5 month onwards, the delay amount is very less. And 6 months, 8 months, 9 months, it is very nominal amount. So the delay is majorly between 1 to 4 months, Your Lordship. There were several other reasons we have given, like we have not even paid to the supplier. Sometimes we have booked the invoices. However, the payment has been made much after the booking of the invoice. That has also been considered by Madras High Court as reasonable cause for not depositing TDS in time. Even that was not considered, Your Lordship, while granting sanction.
Very well. How soon can you
Yeah.
file your affidavit?
3 weeks more.
Tell me.
3 weeks more. 3 weeks more. And we are lots of better. Lord, I am pointing out, Lord, Manual on Prosecution and Compounding 2020, page 70, Lord, should kindly see.
Page?
Page 72. What? Page 72, Lord. Lord, Lord.
Yes.
The above enumerations are only suggestive and indicative in nature, and the CIT is not bound by those and should take a judicious view based on facts and circumstances of each case.
Lordship, they are definitely, the CIT can go and find some other things also as a reasonable cause. They are not, he is not bound by only
Sanction
this
order,
causes.
the CIT, everything is dealt about his financial position. And also, we are relied on the judgment of the Supreme Court. And another judgment also, the Supreme Court is to some extent is my favor. Latest judgment of Court 43 idea. Then I'm sorry, I could not bring that judgment. Well, next day I will cite my next Supreme Court judgment.
Where is that? Yes. Paragraph 23.
Milord,
They've given a
latest,
copy to them.
Milord, latest Supreme Court decision, Milord, 443. 443 item 239, Milord. In that case, the Supreme Court specifically held once there was a non-deposit.
Show me.
But next day I will do that. The
Madam,
necessary.
you please go through the Shawali's judgment. This is more important. Paragraph 23.
Worships, I will go to this. I don't have it with me, Lordship.
Yes. A copy has been handed up to your junior in
Yes,
court.
Lordship.
Please go through it. When should I keep it?
Lordship, if they're filing the reply affidavit, then allow me to file a short rejoinder, Lordship.
So, are you filing affidavit or we shall proceed on this?
My lord.
You are required to file an affidavit or I shall proceed on this?
I agree with you.
Affidavit.
Affidavit.
After the hearing had proceeded, some learned advocate appearing for the respondent revenue authority seeks time to file affidavit in opposition to the writ petition. Full stop. Let such affidavit in opposition be filed within 2 weeks from date. Reply thereto, if any, be filed within a week thereafter. Full stop. List this matter for further consideration on December 19, 2025. Interim order granted earlier shall continue till the end of December 2025 or until further order, whichever is it. Same order will be there. Item. File same affidavit because orders will then there will be parity in the orders. Same order. Item 456. Order granted at the shall continue till the end of December 15. वो कर्म চলে খুবই আমরা উপরে সবই করে দিই yes bad luck today I said yesterday I indicated
No, my lord, I'm grateful. My lord kept it today. I'm grateful. My lord. Maybe may I request that my lord, item number 15 I'm led by senior. He's trying to log in. I think Mr. Padiwala.
Rose, I'm logged in, man.
Oh, yes. So some date.
Rose, is it possible to keep it on 10th December? Is it at all possible, my lord?
Item number 15.
item 15
on
715 715 15 or 14 15 item 716 you are appearing for the 11
No.
As wait for list this matter under the same heading on December 10 2020
Obliged, madam.
So far as item number 14 is concerned, the Lord may have it next week. There's some urgency as I mentioned.
It will appear in the list. It's there in the list.
It's in the list. So it will come up on.
It will come up on Monday again.
Yeah. Request on Wednesday.
So he'll be there.
I'll be taking time.
He'll be taking time and fix it.
Yes. I'll
Thank you.
Deeply.